Judge, we are ready to go.
Good afternoon. The Appellate Division First Department is now in session. Sorry that we don't get to see you today in our beautiful courtroom, but we are back to virtual. Hopefully it will be short-lived. We'll get to see you all in person again. But we've kind of all got this down, so I don't think we should have any problems. I'm going to call the calendar, as Ms. Rojas said. Please do not answer it. I'm just going to do that for the record, and so all the time allotted is clear. People versus Gomez. The appellant has 5 + 1 for rebuttal. Respondent has 5 minutes. 10th Avenue versus Aspen American Insurance. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6. B. Tristan. The appellant has 5 minutes and 2 for rebuttal. AFC has 3 minutes, and the respondent, Winston B., has 3 minutes. Reynoso versus New York City Office of Administrative Appeals is submitted. Kennedy versus Ware and MTA. The MTA has 5 minutes and 1 for rebuttal. The respondent has 5. Hegbelli versus TJX Companies. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. People versus Zambala. Appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Rincon versus New York City Housing Authority. The appellant has 5 minutes and 2 for rebuttal. The Housing Authority has 4 minutes, and third-party defendant Vestar has 4 minutes. Capsuto versus Capsuto. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Radium 2 Capital versus All About Maintenance. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Grocery Delivery versus Flynn. Also, the appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. People versus Cosme is submitted. SHG Resources versus SYTR Real Estate. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. 517 versus 525 West versus Abrahami. The appellant has 5 minutes plus 2. The respondent has 5. People versus Day. The appellant has 5 minutes plus 1 for rebuttal. The respondent has 5. Matthias versus New York Hotel Management. The appellant has 5 minutes plus 2 for rebuttal. The plaintiff respondent has 4 minutes, and third-party defendant, the diner, has 4 minutes. People versus Bailey. The appellant has 5 minutes plus 2 for rebuttal. The respondent has 5 minutes. And the last case, Montgomery versus LROC, is submitted. So I just want to remind you, as Ms. Rojas has already said, please keep your microphones muted, except when your case is called, of course. We know that the one problem with being virtual is sometimes people talk over each other. So you shouldn't be talking over the judges in any case, but please try to be very careful. We'll try to be careful about doing that, and I'm sure everything will go according to plan. So we are ready to start with the first case for argument, People versus Gomez. Just if the appellant attorney can just identify himself or herself.
Yes, good afternoon. My name is John Palmer, appearing on behalf of ACL Gomez.
Okay, so Mr. Palmer, you may begin. Thank you and good afternoon.
Good afternoon, thank you. The level 2 adjudication overstated Mr. Gomez's risk of sexual recidivism and his dangerousness to the community. The mitigating factors in this case, including his exemplary progress while confined and rehabilitative efforts in prison, as well as the totality of the circumstances, demonstrated that Mr. Gomez presents no more than a low risk of reoffense.
Counsel, I have a question. I didn't see any indication of any remorse in the record, and it seems to me that some showing of remorse and an understanding of the significance of his conduct is something that we should certainly take into account in terms of thinking about the likelihood of recidivism.
Yes, Your Honor. There was evidence of remorse in the record. Let me just locate it quickly. Sorry. Mr. Gomez did speak at the SORA hearing, and I can point you to the correct page momentarily. Didn't want to spend too much time looking. I cannot find it immediately. Sorry.
I will look for it. If you
Okay.
tell me it's there, I'll look harder.
All right. Sorry. Well, first, Your Honors, there were mitigating circumstances not sufficiently accounted for by the risk assessment instrument here. Mr. Gomez demonstrated exceptional progress throughout his time in prison. In 0 points for conduct that was not unsatisfactory under Factor 13 did not capture Mr. Gomez's exemplary conduct. Mr. Gomez received 0 disciplinary infractions through 9 years of incarceration up to the point of the hearing. And accordingly, after I think 8 years, Docs had lowered his classification level to medium.
But counsel, if I may, I'm going to piggyback on what Judge Gesmer just said. Your brief emphasizes that there was but one victim here, but there was but one 8-year-old stepdaughter here who was the victim of ongoing sexual conduct. How does that factor into your arguments?
Right, Your Honor. Mr. Gomez's offending did consist of 1 course of conduct against 1 victim that did result in 2 indictments here. And of course, dangerousness is relevant to the risk assessment, and the seriousness of the offense is an aggravating factor that this court should consider among the totality of the circumstances in determining Mr. Gomez's risk of reoffense. In addition to all the other programming he completed, such as
question, counsel. This is Justice Kennedy. How do you address the fact that the SORA court had indicated that the rehabilitative programs that the defendant completed did not provide the intensive sex offender treatment of the sort that the forensic psychologist had indicated would be necessary to address the psychological and emotional issues that caused him to sexually abuse his stepdaughter in the first place?
So, although, Your Honor, that the programming that Mr. Gomez has completed, participated in prison was not what was exactly or specifically noted in the pre-plea memorandum, his participation and completion of the programming he did participate in leaves Mr. Gomez better prepared to avoid reoffense in the future. And all of the programs he participated in were important steps for a person who suffered from addiction, PTSD from military service, and childhood abuse. In addition to that programming, Mr. Gomez dedicated himself to his vocational training while incarcerated and prepared himself for employment upon release. And vocational training is an important predictor of success upon release and reduced recidivism that plainly is not accounted for in the risk assessment instrument, and the hearing court even accepted the assertion that it reduced Mr. Gomez's risk of recidivism in its decision. And the totality of the circumstances here, both aggravating and mitigating, demonstrate that Mr. Gomez presents no more than a low risk of reoffense. He is already.
Counsel, I have a question. I mean, aren't we, if we were going to consider in upward or downward departure, as the case may be, isn't it supposed to be a situation where there are extraordinary circumstances? A very rare case. This is not something that we're supposed to regularly do, but this really needs to have to be a rare case with extraordinary circumstances. And while you've made some points, what are the extraordinary circumstances that should make this case stand out to us?
Well, Your Honor, first, Mr. Gomez has already demonstrated his ability to live in his community without reoffending, as he did not reoffend between the time that he desisted in 2004 and his arrest in 2010. And further, Mr. Gomez was 58 years old at the time of the hearing and still remains incarcerated. And there's a well-established negative relationship between recidivism and age. And it's not a case where someone reoffends at 58 and they're released at 60. There were 15 years here between the last incident and the hearing. And I understand that my time is up for the 5 minutes. So
Yeah, you'll have 1 minute on rebuttal. Thank you for keeping me on track for the time, Mr. Palmer. The Respondents' Council?
Good afternoon, and may it please the court, David Gagne for the people.
Thank you.
Proceed.
You may proceed.
SOAR court correctly found defendant to be a level 2 risk, and that determination should not be disturbed on appeal. Given defendant's repeated sexual abuse of his stepdaughter starting when she was just 8 years old, his risk level cannot be fairly regarded as low. Importantly, the RAI calculates not just the risk of reoffense, but the gravity of the harm that would ensue. Defendant committed undeniably heinous sex crimes against his young stepdaughter, and the gravity of the harm that would result if he were to reoffend cannot be overstated. The defendant raises several purportedly mitigating factors warranting a departure to level 1, but those factors are either adequately accounted for by the RAI and thus not a basis for a departure, or are plainly insufficient to overcome the seriousness of his crimes that resulted in his risk level 2 determination by the SOAR court.
Counsel, I have a question. This is Judge Gesmer. How do you respond to counsel's claim that at the SOAR hearing, Mr. Gomez expressed remorse for what he had done?
Well, Your Honor, I do believe he said that he harmed the victim, he harmed the community, and that he needed to change. So I am not opposed to the idea that he expressed some level of remorse. And unless there are any further questions, I ask that you affirm.
Anyone have any questions? Okay, thank you, counsel. Mr. Palmer, you'll have 1 minute for rebuttal.
Your Honors, the prosecution has asserted that the SOAR court correctly found that Mr. Gomez was a level 2 registrant and risk of reoffense as a moderate level of reoffense. But this court may substitute its own discretion without finding an abuse of discretion in this case. And as the totality of the circumstances here demonstrated that Mr. Gomez presents no more than a low risk of reoffense, we would ask the court to exercise an independent discretion and downwardly depart to level 1.
Okay, thank you both very much. Have a nice afternoon. The next case for argument is 10th Avenue versus Aspen. The appellant.
Good afternoon, Your Honor. Donald J. Sweetman for Appellant Aspen.
Okay, Mr. Sweetman, you may proceed.
Thank you. May it please the court. This appeal is from the Supreme Court's order denying our motion for summary judgment. This is a suit on a policy of insurance, insuring property of a commercial landlord located on 10th Avenue in Manhattan. The landlord asserts that former tenant who occupied the premises under
yes, well, I just want to remind you that we have read the briefs and we are familiar with the cases, but it seemed to me in reading the policy that there was you were basing this on the entrustment, right? The fact that this was entrusted to somebody else because the property was rented out to someone else.
That is correct, Your Honor.
And therefore, if it was entrusted, then any theft would not be covered, but vandalism might be covered. And didn't the plaintiff's witness testify, Miss Wu, I believe was her name, that some of the damage caused was actually vandalism as opposed to theft? And so why should you be entitled to summary judgment until we figure this out a little further?
Because, Your Honor, the Court of Appeals has made clear in the Georgitsi Realty case that in order to constitute vandalism, there must be a showing of willful and wanton, callous disregard for someone's rights, gratuitous damage. This is theft, Your Honor.
Counsel, I'm sorry. You can finish your answer. Sorry.
This is a theft. There was no evidence of gratuitous damage. If we contrast this to the Crest Hill case, you'll note that in that instance, the thieves had done more than just steal property. What they did was they damaged the piping system to the building.
Well, wasn't there testimony from the plaintiff that in fact there was exactly that there was damage to the piping, that the railing was just pulled out of the wall, that things were destroyed, just badly destroyed, maybe as an accessory to stealing it, but it was really, I mean, how can we make a determination now if it was gratuitous or whatever? I mean, damage.
Very simply, Your Honor.
Damage here.
Very simply, Your Honor. For example, with respect to that railing surrounding the VIP area, that railing was cut out very cleanly, and it's depicted in the photographs. And I would refer the court, if I can, to the photographs appended to the plaintiff's opposition below, which are begin in the record at page 454 through 509. And the court will see that what took place here is, there's no question that there was a theft, but theft is not excluded, is excluded. There's no evidence that there was any gratuitous damage, which is an essential prerequisite to a finding of vandalism under the Court of Appeals case.
Go ahead.
Go ahead, Judge Gesmer.
I just don't understand how you can claim that things like ripping wallpaper and ripping wall decorations and breaking paneling are evidence of theft and not of vandalism, of gratuitous vandalism. It seems like a lot of the conduct here could be categorized as that. And maybe you'll ultimately be correct that all of the ripped wallpaper was ancillary to removing items, but it seems to me that given the description by Ms. Wu of the condition in which the premises were left, that there's certainly a question of fact as to whether some of it constituted vandalism. How can you be sure that all of these elements of vandalism were directly related to taking an item that didn't belong to them?
Well, let me, if I can, respond with respect to this issue of the wallpaper, for example. If the court looks at page 503 of the record, photographs depicting that damage are present. There are two points with respect to that. Clearly, according to the plaintiff's own estimate, any wallpaper damage fell within the deductible of the policy. So that's one aspect of it. But secondly,
counsel, this is Judge Gonzalez. I don't know that on the one hand you're answering my colleague's question, and on the other hand, I do believe that you've mischaracterized Jurizzi, which says that no specific intent is required. The issue is whether there was vandalism, which is malicious damage to property. Now, don't you think that a trier of fact has to decide which items were stolen and which items in fact were vandalized, particularly when you talk about the wholesale removal of items in a way that would cause them to never be used again? For example, holes in the wall to remove a TV, removal of paneling, removal of a sink, removal of half a railing. I don't understand your argument.
well, clearly, Your Honor, if the property was removed from the premises, I would suggest that that is indeed the hallmark, a very hallmark of theft, which is excluded. There's no gratuitous.
What about the allegation that he broke the floors? I mean, he didn't steal the floor, did he?
Your Honor, there's no proof that the floor was stolen. However, if Your Honor takes a look again at the photographs, it's clear that you can see where the floor was damaged. In this respect, I would direct the court's attention to pages 486, 487 of the record. In those areas, the metal railing that had been stolen, obviously for scrap, had been removed. So that damage was clearly incidental to the theft. There is nothing here to depict a gratuitous damage necessary to display a level of wantonness.
Counsel, I have a question. How do you address the fact that on page 235 of the record, Ms. Wu had testified that Santos destroyed the place. And then on page 237, she indicated that he destroyed the place purposely. And then there are just other pages in the record as well, where she's saying that he left broken items in place, holes in walls, ripped decorations. So how can this not be vandalism?
Because, Your Honor, under Zuckerman, a vague, unspecific allegation is not entitled to any credit on summary judgment. There is nothing specific, and if again looking at the records, and as produced, there is nothing showing anything other than a theft and incidental damage in connection with the theft.
Okay, Mr. Sweetman, we've gone a little over the time. You will have 2 minutes for rebuttal. Thank you very much. We'll now hear from the respondent, Mr. Blumberg.
Yes, Your Honor. Good afternoon.
Good afternoon.
May it
You may
please the
begin.
court. My name is Craig Blumberg. I represent the plaintiff respondent. I don't have much to add based on what you asked of counsel, but I do want to point out that the case of Benson Holding Corp. Against New York Property specifically states a forceful or violent severing and removal of property that had been affixed to the premises constitutes vandalism, and the loss of the property thus removed is not excluded as theft. So regardless of what counsel is arguing, that it's theft, therefore nothing is covered, is actually completely inaccurate. Even if there was theft and there was damage that was caused by the theft, that constitutes vandalism, and the items that were taken can be considered vandalism. So regardless of all the arguments that they're trying to make, this could be completely covered as vandalism. And the testimony that was given by not only the insured, but there is no dispute that there was a lot of damage done to that property that wasn't solely theft. And the case law and the facts clearly support the lower court's decision to deny defendant summary judgment.
Counsel, I have a question. Is there also an issue as to whether the property was even still entrusted to the tenant at the time this alleged damage occurred? Because by that time there had already been an official eviction from the premises?
Yes, that is the second point in our brief, that there was already an eviction. It was scheduled to be, I think there was an eviction order, but yes, they were already supposed to be evicted. And we did argue that once there's an eviction proceeding and once there's an order for the eviction, that the property isn't still entrusted to them. And that is an argument that we have that we also will address at trial. But what I'm arguing is, even with that issue, the vandalism and the theft damages all will constitute vandalism and would become covered under the vandalism provision in the policy. So yes, there is an entrustment issue here, but just on the other issues, they should not be granted summary judgment.
Any of my colleagues have any further questions? Okay, thank you, Mr. Blumberg. Mr. Sweetman, you have 2 minutes.
Thank you. With respect to the Benson Holding case, first of all, it's a civil court case from 1984. It precedes the Court of Appeals decision in Georgizzi. And to the extent that it suggests that anything other than an willful, wanton, callous disregard for an owner's rights constitutes vandalism.
But
It's-
how
it's
is
just
that an issue that we can decide on summary judgment, counsel?
Because, Your Honor, it's very
By
clear.
looking at the pictures, we could just make this decision?
Yes, Your Honor, you can. And the reason you can is that the property was carried away. That there is.
Counsel, that doesn't answer the question, though. If there's no question that some property was carried away and that the value of the property carried away was probably will not be covered. But the question is whether the property was removed in a way that damaged the property or whether there was other gratuitous damage to the property from which the tenant suffered other damages. I mean, you pointed us to pictures, so I've been looking at the pictures again. And for example, on page 475 of the record, it shows what looks like a surface, the covering of the corner was just chipped away. That wouldn't have it seems, are you telling me that if you look at page 475 of the record, that a trier of fact couldn't find that the chipping away of that corner constituted vandalism? It seems to me that if there's any question of fact as to that we can't grant your relief.
I think, Your Honor, in particular, addressing that specific photograph, you can see in the locations where the railing was, where the tile broke because the railing was removed. And we know from the plaintiff's testimony that that's what took place in that instance.
I want to ask some questions, counsel, about Crest Hill because you quoted it before. And I don't know, as with Georgizzi, I don't know that you referenced this case properly because Crest Hill says that the severing of pipes and fixtures prior to their removal constituted a complete act of vandalism, the essential character of which could not be changed by what was done subsequently, the removal from the premises. So how does that jibe with what you were quoting it for before?
Because
this doesn't stand for this doesn't help you.
Because, Your Honor, in the Crest Hill case, the pipes that were removed were full of water, and therefore their removal flooded the building. There was in this case, there is no gratuitous damage. All of the property that was taken had value, and indeed, the plaintiff observed the tenant in the process of the removal. So that is a distinguishing factor. In addition, the Crest Hill case included different policy language and expanded coverage not set forth in this policy. The Crest Hill case involved a case where acts of destruction in the course of a theft were specifically covered, and that coverage does not exist in our policy here.
Okay, thank you very much. Thank you both. We'll take another look at this. Have a good afternoon.
Thank you.
Thank you. The next case is B. Tristan. The attorney for ACS is the appellant here. Ms. Wassel, is that you?
Yes, Your Honor. Wassel.
Okay, very good. You have 5 minutes and you may begin.
Good afternoon to the court. Assistant Corporation Counsel Deborah Wassel on behalf of Appellant ACS. This court should reverse the family court's order, which found that the father was not a person legally responsible for Tristan. Combined with the negative inference taken for the father's failure to testify, the evidence proved that the father was in fact a person legally responsible for the child. First, the father admitted that he was Tristan's father, and the mother confirmed that to the caseworkers. The father lived in the family's home, including at the time of Tristan's conception, took the children to and from school, and the children referred to him as their stepfather. The family court focused too narrowly on the father's exclusion from the home by the order of protection and confused the requirements to establish paternity with the requirements for a person legally responsible analysis. And I'll also note that this court, which recently decided Acela G, which is, of course, cited extensively in our briefing, decided that case on nearly identical facts. If the court has any questions, I'm happy to answer them, but otherwise I will simply ask that the court reverse in this case.
Okay, well, you have a couple minutes on rebuttal. So the attorney for the child, you agree with ACS, is that correct?
Yes.
Okay,
Yes.
so I've given you 3 minutes if you would, we've given you 3 minutes if there's anything you would like to add, Ms. Egger.
Pretty much not, just that to remind the bench of the chronology. This court and Justice Kapnick was on the Acela G case, was decided 6 months after the and it was the same judge, family court judge, and so she had not the benefit of reading this court's decision in Acela G when she wrongly made a decision that required a level of proof for a person legally responsible well beyond what is necessary in an Article 10 case. This is not a paternity proceeding where there's requirement of proof by clear and convincing evidence, and in which would impose support obligations potentially on the person. This is simply under an Article 10 person legally responsible, as well defined in many cases, and does not require any of the same protections, due process issues as in a paternity proceeding. And this Mr. B in this case is both established by the admissions he made that he was the actual father and the child's last name is his last name, as well as being a PLR. And the court's insistence that he wasn't supposed to be there because the order of protection therefore could not be one of the children for whom the Mr. B was a PLR is completely off base because order of protection. And in fact, my client Tristan was in the home, in the room, when Mr. B again attacked, well, he attacked the mother. And there's just no basis. I think the court has to, would probably acknowledge that given Acela, it was not doing the right thing, but in any case, it should be reversed here.
Thank you, Ms. Egger. Mr. Young, you have 3 minutes.
Bruce Young for the respondent, Winston B. Good afternoon. I think just jumps right out there. Acela G is not this case. It's certainly factually distinguishable. In Acela G, there were 5 children that were undisputedly all that the respondent who was in fact the father, as opposed to what Judge Bing, following the Court of Appeals, that says a careful deference to fact-sensitive issues to determine.
Counsel, I have a question. I see that there is that difference, but I'm not sure if it's a distinction without a legal difference. In this case, the other children were referred to the respondent as their stepfather, so that although they were not his biological children, they acknowledged a relationship to him, and he acknowledged that he was the father of the instant child, as did the mother. I realized there was no legal acceptance of paternity, but the fact that he acknowledged it and nobody disputed it seems to me to bring it pretty close to the Acela facts. So what you've suggested distinguishes it so far, I don't yet find persuasive. And frankly, I'd be curious to see how else you could possibly distinguish it.
Sure. Thank you, Judge Gesmer. I guess critically, the issue of establishing somebody a father, a permanent relationship that creates a bond lifelong between a parent and a child is not the same thing that a statutory 1012G
Counsel, that's not, excuse me, counsel, but that's not what this case is about. If we find he's the LPR, that doesn't make him a legal father. On the other hand, the fact that he's acknowledged parenthood certainly is a factor we can consider in deciding whether or not he's the, I'm sorry, the PL, the person with a legal relationship. But so if by deciding that he's a person with a legal relationship doesn't make him a father, but the fact that he claims to be the father is certainly relevant to our determination of that.
Yeah, I'm glad you brought that up, because there's no, as Judge Bing found, there's no competent evidence of him claiming to be the father. And my experience of 40 years of doing paternity cases establishes that there's a considerable weight of evidence and confounding to have a precise scientific basis at this point as to the paternity. So the merging, maybe he's the father or he's a P, it just shows the weakness of the person legally responsible definition. Because that household was no longer in existence as a functional equivalent.
Mr.
So
Young,
a derivative, similarly situated situation.
Mr. Young, I have a question.
Yes,
I mean, this particular case, your client never, besides not appearing to testify at the hearing, never disputed the evidence that he was the child's biological father.
So I would challenge you, Judge Kaplan or Kapnick, to say that the only presumptions of creating paternity is from a marriage or equitable estoppel. If somebody keeps claiming they are, and then you can't claim that you're not. Those are not the things here that very carefully. And when we moved out of the area of non-marital paternity proceedings to allow the public health law take over, there's a sworn statement that you acknowledge that you have the right of a DNA test. You're creating a relationship at the end of a relationship of a mother that had 4 children with 4 different individuals. They're not similarly situated.
So, counsel, what do you say? What do you say to matter of Daquan, which comes out of our department in 2005, which says that a negative inference can be drawn from a PLR's failure to testify? Are you asking us to overrule that, or are you saying that it's not applicable here? And if not so, how not so?
Thank you for that question, Judge Gonzalez, because a negative inference can only be as much evidence as a presumption as the other evidence that's in the record. And Judge Bing very carefully determined that there wasn't competent evidence of a birth certificate, of a acknowledgement of paternity, of the types of things that are competent evidence. We have a hearsay of a child saying he slept with mommy, and we don't know how far back that goes.
But counsel, are you begging the question? Because isn't the issue when a person is deemed to be a person legally responsible for a child, isn't the question whether they are the functional equivalent of a parent?
We're not arguing that the 3 older children, he was acting at that time as the functional equivalent. He's no longer in that household. That household no longer exists at the time of the child's birth.
But your client asked for visitation with the child just recently, and well, not recently now, but in April, he wanted to visit this child. Didn't this child call him dad?
I'm so glad you asked that question, because if he wanted to, and if he chooses to want to have a relationship with that child, he will then be required, I think, as Judge Bing providently thought out, he would have to go to court and ask to be a father so he could get a right of visitation. Right now, he has no rights with any of these children. And so what's the danger? Until he takes those actions. And in fact, the wisdom of that allows for the concept of bonding something, even in this artificial transitory, person legally responsible definition that doesn't even present in this case anymore. It's a transitory relationship that's no longer in existence.
But counsel, it seems to me that you're ignoring that the case planner testified that both your client and the mother told her that the respondent was Tristan's biological father. And it seems to me that that's an admission against interest by the father, since he could then be found liable for child support. So I don't understand why you're disregarding that as not competent evidence. I agree it wouldn't be competent to make him to establish paternity, but to establish that he's the PLR, it seems to me is certainly competent evidence, especially because it's certainly an admission against interest.
I would say it might be an admission against interest, which would not meet the burden of proof as to paternity and as to a PLR.
This is not a paternity case, excuse me, Mr. Young. This is not a paternity case. I agree with you. It would not satisfy the burden of proof in a paternity case, but this is not a paternity case. And if we find that he's a person legally responsible, that doesn't establish paternity. You're mixing up two different burdens of proof.
I didn't mix them up. The Appellant's brief and the Law Guardian's brief asserted those issues. It's an either or. He's either this or at least he's that.
Okay, but I'm not doing that, Mr. Young, and you're not answering my question. Why isn't his statement to the case planner that he was the child's father admissible evidence on the question of whether he's a person legally responsible?
It probably is some evidence towards the Yolanda D factors upheld recently. Again, those 4 factors, which this court is looking to go outside of, using, as Appellate G did, to use these countervailing factors or to expand the outer limits of the neglect statute, as opposed to actually addressing what is the foreseeable issue of danger or risk or imminent harm or risk to a child. There's no establishment of a risk of harm to the child, so you couldn't establish the derivative neglect either.
Okay, I think we've gone way over the time. Does anybody else have any further questions? Okay, thank you very, very much, Mr. Young. Ms. Wassell, do you have any rebuttal?
Just very briefly, Your Honor.
Sure.
As Judge Gesmer pointed out, the statute doesn't distinguish between a parent or a PLR for purposes of neglect proceedings. They are functionally equivalent. And there was evidence that this person was both the father and, in the alternative, a person legally responsible. I'll just note as a final point that the negative inference combined with the father's admission to the caseworker that he was in fact the biological father was sufficient for this court to reverse in Appellate G, and it should do so here as well. If there are no other questions from the court, ACS rests on its brief and asks the court to reverse.
Justice Kapnick, I have one question.
Sure, go ahead.
Mr. Young had indicated that the children's statements were hearsay, but weren't the children's statements about the father, the respondent being the stepfather, they made other statements. I mean, wasn't that admissible under 1046 since they deal with allegations of abuse or neglect? Wasn't that admissible?
Yes, absolutely, Your Honor. Children's statements in abuse and neglect proceedings are admissible automatically under 1046. They're not hearsay in these kinds of hearings, so they're absolutely admissible.
Thank you.
Okay. Any other questions? All right. Thank you all very much for the arguments. Have a very nice day. We'll take a further look at this. The next case for argument is Kennedy versus Ware. Ms. Cortia?
She was on the telephone when you first called the calendar. I'm not sure where she is now. I also wanted to point out to the court.
Oh, wait. If she's not here now, I'm going to.
Can you hear me now?
Oh, are you Miss Cortia?
Yes. I apologize.
You're not visible. You're just calling in.
Correct. I've been on the line the whole time. I didn't realize that the phone itself muted. It somehow muted me.
That's okay. All right. You have 5 minutes, Miss Cortia. Okay.
Thank you. I will be very brief. May it please the court. We represent MTA Bus Company and its bus operator, Kevin Ware, with regard to a motor vehicle accident involving the plaintiff. The
Right.
plaintiff was an employee and is still an employee of the New York City Transit Authority. And one of the items of discovery that we had requested but was refused was plaintiff's personnel file, including his medical records from the New York City Transit Authority, based on his testimony that he had annual examinations, annual physical examinations, and he testified that prior, the court below permitted defendants to obtain a single evaluation. That was a single post-accident evaluation. It is our position that we're entitled to all the evaluations, and particularly the evaluations that occurred post-accident, because it is plaintiff's testimony that he returned to work, that he went for a physical within 1 or 2 months prior to returning to work, which would then suggest that he was cleared to return to work, and that would be obviously useful and necessary to the defense to rebut the claim of inability to work. So it is our position that these fitness for duty evaluations are directly relevant to this case. And another reason why the personnel records are important is there's a 1-year period post-accident where plaintiff apparently couldn't work because his license was suspended because of a DUI conviction. That was in 2017, and this accident was in 2015. So that occurred after the fact. So another reason we should be permitted an opportunity to review the personnel record, including all medical records, is the claim of inability to work because of this motor vehicle accident, as opposed to some other reason. We present through plaintiff's own testimony, we have another reason why he couldn't work. His commercial driver's license was suspended. So, and in addition, there's also testimony by the plaintiff that, he was in various fender benders throughout his time as a bus operator. Well, then that also begs the question about what injuries he may have sustained during those incidents. Now, the second category.
Counsel, let me ask you something. Yeah. If the court were inclined to perhaps let you see some additional records, would it be appropriate or wouldn't it be appropriate for there to be an in-camera inspection, just in case there's other things in that record that maybe should, in that personnel file, that should not be that are not really eligible for discovery value because there may be other types of documents or other kinds of injuries that are unrelated to the injuries he suffered in this case?
Yes, Your Honors, and in our, we had said this below, and I maintain it also in my brief. We represented that we do not object to an in-camera inspection, and I stand by that representation that we had made throughout this disclosure process. So I'm sorry.
No, go ahead. Okay, thank you for confirming that.
Yes, I was going to proceed. The other category or the other type of record we were seeking to obtain are records regarding the time he was in a federal penitentiary and he underwent at least one surgery that we know of, which he said was for an umbilical hernia repair. That's by his testimonial account.
So,
We
counsel, if
are
I may,
not-
this is Judge Gonzalez. So you're simply seeking confirmation that that was a surgery for a hernia and not a surgery for anything else? Because it doesn't seem that a hernia surgery in 1991 is exactly relevant.
One of the reasons we do want access to this record, and again, we would of course consent to an in-camera inspection, is to confirm what type of hernia it is. And also the fact the hernia involved the abdomen, I don't really think it's far-fetched to say that he's claiming lower back injury. He had a discectomy. And usually hernias are caused by lifting something heavy, and it involves back pain. And so I don't think it's very far-fetched to think that this could be, so completely unrelated as to be non-discoverable. So we would like the full medical record. And again, because that's the one and only surgery we know of. But we would like his complete medical record. And again, certainly we would consent to an in-camera inspection on that issue.
Okay, we've run out of time, so why don't we hear from the respondent, and you'll have a minute to rebut, okay?
Absolutely.
Yeah, thank you. This is Dave Schwartz. May it please the court, I represent the plaintiff respondent. The claim that they want to see the record because an umbilical hernia might have been caused by heavy lifting in 1991 concerning injuries sustained to the neck and back and right shoulder in a 2015 injury, I submit, is very far-fetched, and it amounts to a fishing expedition that the court below did not abuse its discretion in denying to the defendant appellant. We agree, the court, I'm sure, is aware that you waive your confidentiality only with respect to the parts of the body injured here. The plaintiff was extensively questioned at a deposition and at a statutory hearing, and he denied any prior injuries to any parts of the body claimed injured here. As to
so counsel, if I may, this is Judge Gonzalez. So the MTA indicates that it has no objection to an in-camera review of the plaintiff's medical records and other information in the TA personal file. Does the plaintiff have an objection to an in-camera review?
If the court orders it, of course not. But I don't believe that the court should formulate a policy that says every time a defendant demands irrelevant records, you're going to burden the lower court with in-camera reviews of all these irrelevant records. So that's my only thought on in-camera review. Of course, if the court thinks that's the proper remedy, of course it would be. But again, I think that you don't want to create a policy where every defendant demands an authorization for every record, starting with the pediatrician to whom the plaintiff was handed as a newborn up to the time of the accident.
Okay, well, that's going a little far, but Mr. Schwartz, but it may be that there may be some documents in his employment file that do relate to some of the to related injuries that might be appropriate. And if we did something allowing for an in-camera review, then really there could be no prejudice to either party.
I can't dispute that at all, Your Honor.
Okay, Mr. Short, were there any other points you would like to make for us?
Well, I think I understand how I think the court is leaning towards ruling. I was going to talk about the period of time where the plaintiff was unable to work because he had his license suspended.
Yeah, you could take a minute.
I don't think the defendant has a windfall because of that. And the plaintiff, it'd be one thing if the plaintiff suspiciously went back to work the day after the license suspension ended, but that didn't happen. He was unable to work for another couple of months, and then he went back to work. And so the interest in a physical exam that permitted him to go back to work, I don't quite understand. If I understood my worthy adversary here, she said it's necessary to prevent or limit a claim for an inability to work, but he didn't claim an inability to work after he went back to work, and he's been working ever since. So I don't quite understand why this examination that found him fit to work is of any interest at all.
So you're saying, if I may, that there's no issue as to permanence?
Permanence and inability to work are two different things. The answer is sure, there's permanence. I mean, he's got to have permanence, otherwise he wouldn't have a serious injury just being a motor vehicle accident. Of course, he has a serious injury as defined by 5101 of the insurance law. And of course, that implies permanence. But, you know, I could have a horrible disability, be unable to move my arms or my legs and still be able to do what I do.
Any further questions from the bench? Okay, Mr. Schwartz, thank you very, very much. Ms. Corchi, you have 1 minute if you'd like to respond to anything.
Yes, I would just like the court to take a look at the allegations in the Bill of Particulars on pages 94 through 96 approximately. There are many allegations of permanency, but what's interesting is there's also an allegation, and it may be generic, but nevertheless, it is still in this BP. It's after describing cervical, lumbar, and the right shoulder injuries and the surgical intervention, the BP continues, all injuries were caused, aggravated, exacerbated, and/or precipitated by the accident. So I think if you're going to claim aggravation, you're going to claim exacerbation, that the defendant can certainly explore if you had a prior pre-existing condition. And I don't think we should be bound by, well, he said no, he didn't at his EBT. I think your BP, you chose to make an expansive allegation, and we are entitled to discovery on that. Thank you.
Okay, thank you both very much, and have a very nice afternoon. Thank you for coming
Thank you,
in
Your Honor.
or for appearing
Thank you, Your Honor.
online. Okay. The next case for argument is, I'm probably pronouncing it wrong, Hegbelli versus TJX Companies. Counsel for the appellant, Mr. Gorman, I believe.
Yes, good afternoon, Your Honor.
Good afternoon. You may proceed.
Can you hear me okay?
So far.
Good. Okay, good. May it please the court, Kenneth Gorman for the plaintiff appellant. Justice Reed's order granting the plaintiff an adverse inference charge was binding on the trial court. Under the law of the case doctrine, it was not merely an advisory opinion that the trial court was free to disregard. And there's no rule by statute, case law, regulation, which provides that an order issued by a judge after considering an issue that was fully briefed in connection with a motion made on notice during pretrial proceedings, that this order would be subordinate to a ruling by a trial judge. And the defendant who filed the notice of appeal from Justice Reed's order abandoned it. And it's also well settled that an unappealed order is the law of the case, and a court of coordinate jurisdiction is not bound by it. It looks like the trial court confused Justice Reed's ruling with an evidentiary ruling, but this wasn't an evidentiary ruling. It was an adverse inference charge, and this is binding. And I don't really think there's much to say about it. It's pretty clear cut.
Judge Reed actually specifically ordered, did he not, that plaintiff shall be entitled to the issuance of an adverse inference charge against defendant.
It couldn't be more clear than that. He was pretty definite. And the plaintiff's attorney clearly stated at trial that he prepared his case based on this adverse inference charge. Got completely taken off guard. And the case is cited by my adversary, trying to justify Justice Reed's ruling. They're not on point. One is a Cochran versus public administrator from Imperial County. That was a second department case that dealt with an evidentiary ruling. This is an adverse inference charge, and I have not come across one case where a trial judge was free to disregard an order issued by a judge in connection with a motion made on notice. Now, with
You
regard
want to
to
reach
res
any of your other points?
Sure. Res ipsa, the trial court incorrectly found that the element of exclusive control was not established because the plaintiff and others may have had access to the table, as the defendant submitted no proof that third parties tampered with it. But the question was not whether the public had access to the table, but whether the mechanism that caused the table to fall on the plaintiff's foot was generally handled by the public. Now, the plaintiff testified that the table was not flush with the floor, that it was wedged between two pieces of furniture, and that it was standing on two legs.
Well, let me ask you something. Wasn't there a case from our department about 20 years ago, the Rivera-Emmerling case against Fortunoff, where it says that where the accident involves an instrumentality on an open sales floor, as this was at forget what store was this? Well, whatever. That the requirement of exclusive control is not met. How did we get around that? I mean, this is certainly an instrumentality on the sales floor. This was a table with merchandise on the sales floor at the store.
Well, in that case, yeah, we have the testimony of Mohammed Say, the operations manager at Marshall's, and he testified that the table which fell on the plaintiff was arranged by an employee in the store's home section at page 411 of the record, and that he walked past the table many times that morning, and that the position of the table never changed from the time the store opened up until the time of plaintiff's accident. And the only way that we could corroborate Mr. Say's testimony was the video, which was not produced and which we had an adverse inference charge for. So, I mean, but I'd just like to point out, in Dawson versus Natural Amusements, this court held that the defendant's summary judgment motion was properly denied on the res ipsa, where the seat that the plaintiff was sitting in a movie theater collapsed. It wasn't necessary that the defendant had sole physical access to that instrumentality in this public venue, where the defendant's negligence in inspecting and maintaining the seat was a probable cause of the accident. And the defendant's failure here to explain why the table fell on plaintiff's foot warranted charging the jury on the res ipsa. And it was apparent that the defendant set the table up in such a dangerous manner that it was prone to falling on unsuspecting patrons such as the plaintiff. And it must be stressed that there was no evidence at trial, none, that any member of the public tampered with the table, and that the only objective evidence that would have confirmed this was the video. However, Mr. Say admitted that when reviewing the video, he never started it from the time his shift started at 9:30 in the morning to see if anyone tampered with it. And Tyrone Johnson, the loss prevention investigator who operated the surveillance videos, only reviewed that segment of the video, which was 5 to 10 minutes long. He did not roll back the video to the beginning of the day, to 9:30 a.m., which he admitted at page 449 of the record could have easily been accomplished. Mr. Johnson further acknowledged that he rolled the film back to 9:30, that had he rolled the film back to 9:30 a.m., he would have been able to ascertain what had transpired that morning with regard to the placement of the table. And given that this could have been easily corroborated by the entire video, which the defendant did not produce, and which Justice Reed issued an adverse inference charge. I mean, the trial court's refusal to charge res ipsa under these circumstances was reversible error.
Okay, you will have, does anyone have any questions? You'll have 2 minutes for rebuttal after we hear from the other side, okay? So you can address those points. Thank you very much, Mr. Gorman. May I hear from the respondent at this point?
Yes, good afternoon, Your Honors. This is Philip Ziegler for the respondent. I had a little bit difficult time hearing what some of Mr. Gorman was saying, but I got the gist of it from his brief, basically. First of all, it's telling that, Mr. Zolan, the trial attorney, is not arguing the appeal. Obviously, Mr. Gorman's a very accomplished appellate attorney, but he was not present for any of the conferences, for any of the motion arguments, for any of the witness testimony or anything during the trial. This was a jury trial.
I mean, counsel, not for nothing, but it's very common that different lawyers argue the appeal, then try the case. I'm not going to make any inference based on that, but The
only thing I'm saying that for is because there were
Judge Gesmer, you're on mute. I think you're trying to ask questions. I just thought I'd tell you that.
It's just, thank you. Mr. Ziegler, I have a question for you. Counsel said that he was not able to locate any cases like this one that came out as the trial court did. And I'm curious if you can tell us about any cases where a trial judge was permitted to disregard an order directing an adverse inference by a motion judge on a motion involving a discovery sanction. Because that's really what's at issue here. It's not an evidentiary ruling, but a ruling on the issuance of a discovery sanction. So are there any cases like this where we approved the subsequent trial judge disregarding the motion judge's order?
Yeah, I believe you're correct, Your Honor, because this is clearly not a res ipsa case. So that issue really was never, in my mind, something that we had to discuss. It is about the adverse inference charge. The adverse inference charge, first of all, from Judge Reed's decision, he basically indicates that the sanction, that would be the only sanction that it should be limited to would be the issuance of an adverse inference charge. He doesn't actually say that the adverse inference charge should necessarily be given. He just says that basically that he's not dismissing my defenses. He's not preventing me from putting in any evidence, including the video that we did turn over, which in turn was the only video. The problem with the adverse inference here is you can't charge something that wasn't true. All the evidence at the time of trial.
Counsel, I think this is Judge Gonzalez. I think you're skirting the issue because isn't the big issue here that this was a discovery sanction, one chosen by Judge Reed in lieu of dismissing the case?
Right, and based on Judge Freed's decision, the Cosgrave case was a case that she relied on to say that that was just advisory, that she couldn't.
Yeah, but I mean, I know that I agree that that's what Judge Freed said, and I understand how she was, her analysis. But when I look at Judge Reed's order, which I mentioned during Mr. Gorman's argument on page 212 of the record, I see it saying order that plaintiff is and shall be entitled to an issuance of an adverse inference charge against defendant with respect to the missing surveillance video. Now, by that time, I understand the jury would have heard the testimony that they would have heard, and they might decide to ignore the adverse inference charge. But I don't know if I don't believe under the circumstances of this case that the judge was just was allowed to not give any adverse inference charge. I mean, just because you give an adverse inference charge doesn't mean you have to follow it. There's an adverse inference charge, and then the jury's heard the testimony and they make their determination.
That's my other point, Your Honor. The adverse inference charge does not equate to liability. So this is not like a res ipsa charge where automatically then there would have been liability against my client. There's no evidence here at all that regardless of whether the judge decided to give some sort of adverse inference charge based on the evidence, that would have made any difference in that verdict. The verdict was not contrary to the weight of the evidence in this case. That's the most important thing. You don't
Counsel, you're conflating. I really do believe that you're conflating the issues. The issue is that there was an order which included a sanction, and a judge of concurrent jurisdiction, in a same level court said, I'm not following it. There was no motion to re-argue, there was no motion to renew, and the appeal was abandoned. So you fought for this. You fought against the adverse inference charge. What's the result?
What I did, honestly, at the time of trial was I asked for the video that we had that was disclosed, which was the only video that was in existence, to be shown at trial. Plaintiff agreed to have that video shown. Now, whether there was some other video that he claims existed, which, again, turns out there wasn't, and I knew there wasn't, doesn't mean the fact that if she wanted to give an adverse inference based on the evidence, she could have the judge. But I didn't fight for, all I fought for was to make sure that my evidence was put in, which Judge Reed did not preclude. Judge Reed said, you can show any evidence you want, including that video. That had nothing to do with an adverse inference charge being given. And the adverse inference charge was not determinative in the verdict being rendered. So,
Mr. Ziegler, excuse me, this is
Mr. Verdict that was given by a jury.
I have a question, Mr. Ziegler. This is Judge Shulman. My understanding is that when Judge Reed issued his order,
Judge Reed.
That was the discovery. Judge Reed.
Yeah, I can see what the confusion is because you have Judge Reed and Judge Freed. So.
Right. When Judge Reed issued his sanction order, it was in the context of where the plaintiff was arguing that there was a different video referable to the accident report and what she believes existed than the video that was shown in court. And while you've repeatedly said that there was only one video, it appears that Judge Reed determined that there was a missing video. That's why he imposed a spoliation sanction. And therefore, if you had disagreed with that, and if your client's position was that there was only one video and that was the one in court, then you should have appealed Judge Reed's decision or moved for re-argument, but none of that happened. So the bottom line is would you then agree that based on that discovery sanction that it was not harmless error, and Judge Reed should have granted the plaintiff's request for an adverse interest charge, regardless of the evidence that was brought in by your client at trial?
I can't agree with that because, again, I think it is harmless error in the fact that there was no additional video, and more in thing, what was this other video had shown? The video that was turned over shows the plaintiff in the video. It shows her reaching over for the table. I'm not sure what other video he thought there was there or not, but it wasn't determinative in my case because all I knew was that was the only video. It shows the plaintiff. At the time of trial, if the judge wanted to issue this adverse inference, fine. As Judge Kapnick indicated, the jury would have just said, well, there was no proof of any other evidence of that. That's not going to equate to liability. That shouldn't overturn the verdict because it's not determinative here. If it was a reciprocal, the liability would attach, that might be a different story. But this is not equates to liability on my client's part.
All right, we've gone over the time. I'm not sure I said that the jury wouldn't decide. I said the jury, had the right to figure it out once they got the adverse inference charge. Okay, thank you for your argument, Mr. Ziegler. Mr. Gorman, you have 2 minutes if you have any rebuttal.
With regard to Justice Reed's decision, he noted that the plaintiff asserted that the only video provided by the defendant did not contain any of the images described by the defendant's employees at their depositions, and that the defendant failed to offer a satisfactory explanation for these inconsistencies. Now, had they offered a satisfactory explanation for these inconsistencies at trial, I could understand, but they did not. And with regard to consenting to the video, the plaintiff argued, and he correctly argued, that there was no evidence to show how the videos were created. He never consented to it. He emailed a proposed stipulation to the defendant's attorney, stating that he would withdraw any objection to admitting the video into evidence if the defendant would agree to giving the jury an adverse inference charge at page 240 of the record. However, the defendant's attorney did not sign the stipulation, and he stated that he would not agree to it. So he never consented to having this video entered into evidence. Given that the adverse inference charge wasn't issued, I just don't see how we can get around this.
Okay, just want to tell you for future, whatever system you're using is really very garbled. So it was a little difficult. Okay, thank you both very much for the arguments today, and have a very nice afternoon. Thank you.
Okay, bye-bye.
The next case for argument is People versus Zambala. Ms. Gonzalez?
Yes, good afternoon, Your Honors.
Good afternoon. You may proceed.
And thank you. And may it please the court, Alma Gonzalez for Mr. Zabala. Mr. Zabala was not told the specific PRS term on his 2003 conviction prior to his plea. And as a result, that plea was unconstitutionally obtained and should not be used to enhance his sentence here. In order to show at the predicate hearing that the conviction was unconstitutionally obtained, Mr. Zabala showed substantial evidence that he had no actual knowledge of the specific PRS term, and that he was prejudiced in this case. There was a reasonable probability that he would not have accepted the plea had he known that there were 5 years of post-release supervision attached. I'll begin with the actual knowledge point. Here, the plea minutes in the 2003 case show that he was not told that there was 5 years of post-release supervision attached. Mr. Zabala also testified at the predicate hearing in this case that he wasn't advised prior to the plea of the 5 years. And subsequent to the plea, there was an October 2002 appearance in which the court again reminded Mr. Zabala about the promise in the case, and the court said that he was promised 5 years. The court did not mention that there was 5 years of post-release supervision. So there's no contrary evidence here indicating that Mr. Zavala at any point prior to taking the plea actually knew about the 5 years.
Counsel, this is Judge Gonzalez. So can you explain the delay in objecting to the PRS? It took him all of 14 years to figure this out. And he did testify at one point that he learned about the 5-year PRS a few years after sentencing, or sometime between then and 2.5 years. He was extremely unclear.
Correct, Your Honor. And I would first like to note, it's not a surprise that he couldn't remember exactly when he found out. As Your Honor pointed out, 14 years had passed by since that point. So I don't think that that's indicative of him having prior knowledge. But as to the delay in bringing up this issue, Mr. Zavala also did testify that by the time that he found out and realized, this doesn't just mean that I will be released on parole and then, complete parole outside for 5 years. This meant that, there was an additional term to the sentence. He thought it was too late to do anything about it at that point because sentence had already been imposed. And that's at the hearing minutes at page 48 and 50. And I would also like to note, I understand that Mr. Zavala was indeed told at the time of sentencing that there was this 5-year term. But one, that's not indicative of what he knew before he took the plea. And two, at that time, he also wasn't really aware that there was a meaningful distinction between parole and PRS. I believe our brief lays out the reasons why, mainly because, in the course of the 1997 predicate and the 2003 predicate, Jenna's law was passed, which is what finally imposed post-release supervision.
So let me ask you about something very different. You referenced the reasonable probability in your eyes that if he had known about the length of his PRS term, he wouldn't have pled guilty, right?
Correct.
This is in reference to the 2003 conviction, right?
Correct, yes.
Okay, so the exposure was 10 to 25 for Rob 1, and he pled guilty to Rob 2, and he got a sentence of 5 years plus PRS, right? Which ended up being 5 years PRS. So your argument is that there was a reasonable probability that he would not have pled guilty to a lower count with a much lower sentence and rather have risked 10 to 25 for robbery 1?
Correct, Your Honor. And I also understand that, under normal circumstances, that highly would cut against us. And I'm not trying to shy away from that. But I think that his plea withdrawal motion is highly indicative of the fact that he would not have accepted the plea because, when he tried to withdraw his plea, he was told by the people that they would be seeking the 25-year maximum on that top charge if he succeeded on his motion. And even knowing that, he still proceeded to try to get his plea back. And so I understand, again, in normal circumstances that would cut against us. But here we do have Mr. Zavala trying to withdraw his plea, being told and reminded again of that exposure, and still deciding that he wanted his plea back and wanted to go to trial.
Okay. Does anyone have any further questions right now? All right, Ms. Gonzalez, you'll have 2 minutes of rebuttal. If we can hear from the people now.
Good afternoon, Nathan Scher for the people. May it please the court. Your Honors, defendant was properly sentenced as a persistent violent felony offender. The totality of the record makes clear that defendant knew of the length of his post-release supervision term when he pled guilty, leading to his 2003 conviction. At the plea proceeding for his 2003 conviction, the court announced that it would sentence him to 5 years of state prison and post-release supervision, which is reasonably—
I have a question, because when the court said that, after the court said that, did the defendant or his attorney indicate that they didn't understand, that they were confused, they objected to what the court said, or asked for clarification after the court said that?
No, Your Honor. At no point during that proceeding did defendant or his attorney express any confusion or request clarification of the term of post-release supervision, which made clear that they already knew about it. At sentencing for that 2003 conviction, the court sentenced defendant to 5 years determinate, 5 years post-release supervision. And again, neither he nor his new attorney said anything to suggest that the post-release supervision term was unexpected. And as Your Honor brought up, defendant did not raise an appellate claim or file a post-conviction motion about this issue or bring anything about this issue for the 14 years following his conviction. He only raised the issue of post-release supervision after he was arrested in the instant case and became worried about an increased sentencing exposure. But in any event, Your Honors, even if defendant did not—
Can I just ask a quick question? There's no bar, however, as a matter of time in waiting that long, correct?
No, Your Honor, there isn't a bar necessarily, but I believe this court has held that it's indicative that, excuse me, I'm getting ahead of myself. No, Your Honor, there is no bar. But that goes a bit towards the prejudice section, and it's our position that even if he did not learn of the length of his post-release supervision term until after he pled guilty, he was not prejudiced such that had he known about the length of his post-release supervision term, he would not have pled guilty. And in particular, as to the 14-year length, if this term was truly so important to him, the post-release supervision term, he would not have waited 14 years to raise the issue. And I believe that's where this court has held that that is indicative of a lack of prejudice. But of course, defendant at the hearing consistently made clear that his focus was on minimizing his prison sentence and that he did not want to go to trial. As was referenced, he was originally charged with first-degree burglary and robbery and had a sentencing exposure on either of those charges of 25 years, but he was able to plead guilty to a single reduced charge and received the statutory minimum 5 years in prison, followed by 5 years of post-release supervision. And that is a deal that a reasonable defendant, let alone one whose primary concern was to do as little jail time as possible, would not have turned down simply because he didn't know the exact length of the post-release supervision term. And so it's our position that defendant was aware of the length of the term and was not, excuse me, even if he did not know of the term, length of the term was not prejudiced by it. And if there are no further questions.
I do have a quick question, if I may.
Yes, sure.
I understand that the defendant violated parole at some point. Does that have any bearing on your argument or your adversary's argument?
I'm sorry. Could you repeat the last part? I spoke over you.
I understand that the defendant violated parole at some point in time. Mm-hmm. Does that have any bearing on either of your arguments?
I think the only bearing that it would have in this case, because I think you're referring to either the 1993 or the 1997 conviction, is that he would be aware that at some point, sometimes, individuals have to serve a what is now post-release supervision component after they serve their prison sentence.
Okay, thank you. Ms. Gonzalez, you have 2 minutes.
Thank you, Your Honor. I'll start with Justice Kennedy's question regarding the fact that Mr. Zavala and his attorney did not object at the plea proceeding, and I would like to connect that to Justice Gonzalez's point about the parole violation. The parole violation was on this 1997 conviction, and it was about a year before he pled guilty in 2002. And so, you know, it's again no surprise that Mr. Zavala didn't object to this, because in his mind there was no, you know, post-release supervision means parole, just as he had served previously, and he knew that there was a risk when there is parole, that he could be reincarcerated if there was a violation, because he did have that violation a year prior and he was subsequently reincarcerated. And the meaningful distinction here is that because he just thought, it's post-release supervision, he was equating that to parole. He believed if I violate parole, then I would just be reincarcerated maybe for a few months until the end of the 5-year prison term. And that obviously would not have been the case here, because it would have exposed him to a maximum of those total 5 years if he still hadn't served part of them. And also that going to the people's position that, well, he didn't bring this up, and if it was so important to him, he would have raised this. I would like to note that he wouldn't have actually recognized the distinction between parole and post-release supervision until close to the end of his sentence, because that's sort of when the distinction would have become meaningful, at that point when he was going to be released. And then he would realize, oh, well, why is the maximum expiration date on my parole really post-release supervision 5 years later? That I would also just end on the note that there is no time bar to bringing these claims, and it is of no consequence that he only brought this up after the instant case came about, because this issue wouldn't have been discovered had he not had another case after that 2003 conviction. So for all of these reasons, we do believe that he was erroneously sentenced as a predicate in this case, and we ask that your honors remit for resentencing.
Thank you. Thank you both. Have a good afternoon.
Thank you.
The next case for argument is Rincon versus New York City Housing Authority.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. I'd like to focus mostly, if I can, on the 240 claim. As the court knows, not only was our motion for summary judgment denied, but the 240 and the 241-6 claims were both dismissed. We believe that this court's recent decisions in 4 cases, Patos against City, Salcedo against Sustainable Energy, Albuquerque against City of New York, and Diaz against Ravi Realty, which are cited repeatedly in the brief and reply brief, stand for the proposition that if a construction worker is working below other construction workers, that construction worker is entitled to some type of protection from falls with respect to objects, instrumentalities, or items that ought to be secured. The assertion that a wrench does not present that foreseeable risk, in our view, was rejected expressly by this court in Brust, B-R-U-S-T, against Estee Lauder. It's 184 AD 2nd 474. And I'm quoting from the decision. This isn't Brian Isaac. This is the Appellate Division, First Department. Plaintiff, an employee of third-party defendant Rise Steel Corporation, Erection Corp, was injured when struck on the upper right arm by a 15-inch spud wrench that was dropped above by a fellow employee. And then it goes on to say something else. That's exactly the situation presented here. I would urge the court to look at page 208 of the record. It is a photograph of the wrench that struck the plaintiff. I would submit that that is not an insubstantial object as a matter of law and as a matter of fact. I would also point out to the court that in Hill against Access Group, that's at 122 AD 3D 428, and in the Salcedo case and in the Diaz case, we had situations where a worker dropped an object from a height, striking the plaintiff. In those cases, the cause of action was either sustained or was determined to be violated as a matter of law. I know one of my adversaries is going to tell you that Autar changes this rule because the Autar court held that, as a general rule, 240 doesn't apply to objects that are being held by hand. But that deals with objects that are on the same level. This court has long held that if you drop an object from a height, the Autar decision does not apply. I would also point out that the plaintiff in Autar actually won, with the Autar, the Court of Appeals in Autar basically changing the law, saying that if an object ought to be secured, it falls within the ambit of the statute. Let me also point out for the court that the accident reports and the testimony of the defendants themselves absolutely supports plaintiff's theory of liability. The accident reports, which are on 203 to 209 of the record, denote that they should prohibit stacking and that tethering devices should be used to prevent this type of event. I'd also ask you, if you could, to look at the admissions that this was a violation of accepted practices. Mr. Scarcella from the Housing Authority made that admission. It's on page 433, line 4 to line 20. And Mr. Francola of Vesbar himself said at 542, line 3 to 543, that these were violations of accepted standards. Finally, I'd ask you to take a look at the tethering device that is on 628 of the record, which shows that these devices could have been used very efficaciously without compromising the work. And finally, the affidavit of Mr. Temple, which was not even submitted by the defendant housing authority, does not in any way establish a defense to the claim. We cited to at least 12 to 15 cases where this court has rejected defendants' affidavits.
Mr. Isaac, may I ask you a question?
Sure.
One of the experts, I believe it was Vespar's expert, said something about that the wrench could not have been functionally employed if it was secured or tethered, and that apparently has been contradicted or by not only experts but just some of the witnesses that testified. Correct? I mean, there was plenty of testimony, wasn't there, that it could have been used. I mean, they weren't going to glue it onto the side of the building. They were going to tether it so it could be used, and at least it wouldn't fall and hit the guy in the head.
Yes, that's absolutely correct. That's why I cited you to page 433 and 542 to 543 of the record, because those were admissions made by the defendants. And Judge Kapnick, if you give me 15 more seconds, I won't go over my time. What Mr. Temple
You never
said,
do. We'll let you.
I think I may be close. I have my.
All right, go ahead.
All right, I got 5 seconds. I'll get it done fast.
I'm not that particular with my clock.
What Mr. Temple said, this is 600 and 601, that the tools, that plaintiff's theory was that the tools should be tethered to the parapet wall. That is not plaintiff's theory. It should be tethered to the belt and the tethering belt. So he misstated the argument in order to create a defense that didn't exist. And if you have no further questions, I'm happy to rest on my brief, and I'll talk to you if I have to on rebuttal. Thank you.
Okay, thank you, Mr. Isaac. Counsel for the Housing Authority?
Good afternoon, Your Honor. Jason Meneses from Cornell Grace PC for Respondent NYCHA.
Good afternoon.
May it please the court, may I proceed?
Sure.
Here, I think the facts are clear. So the subject wrench was not an object that required hoisting or securing for the purposes of the undertaking at the time of the occurrence. Your Honor, I believe you're on. Yep, I believe you're on mute.
I am. Thank you. I don't think you're starting at the right place. I think the first issue is the fact that there was stacking of trades, and the NYCHA construction manager, Mr. Scarella, agreed that it was improper for workers to work on the building roof at the same time that workers were working on a hanging scaffold on the side of the building. So don't you have a problem from the start?
So, Your Honor, respectfully, I think the issue of stacking is ultimately a red herring here. The plaintiff was working on a.
Well, let me ask you another question. So the problem here is that you have one guy over the other guy, and the other guy goes plop, and the wrench comes down, and it's a wrench like this big, right? And it comes down and it hits the guy. So your first problem is the stacking of trades, and then the second problem is that it's not tethered. How do you get around that?
So what I would say, Your Honor, is ultimately Mr. Malo, the co-worker that dropped the wrench, was working on the roof behind a parapet wall, which was there to essentially prevent things from falling over. We understand that, look, there are certain times where incidents do occur at a construction site, but doesn't necessarily, just because an object falls, doesn't necessarily, mean that Labor Law 240 applies.
Counsel, I want to go back about the red herring, because we also have plaintiff's testimony, and I'm looking at pages 246 and 254 of the record, where he said that workers were told not to work below one another at the site. Lines 19 to 21 on 246, lines 8 through 13 on 254. The plaintiff says that they were directed not to work below one another. So how is that a red herring?
So so I guess my impression that my understanding of the stacking is different than I guess how the appellant is presenting it. So my understanding is stacking would be working above each other, let's say on the scaffold. Our position is that because he's working on the roof behind the parapet wall itself is the device to prevent things from falling. And I think there was testimony about that. And
but that's not
parapet
how
wall didn't do
STV's
that.
accident report reads. The accident report itself says that the contractor is directed not to stack trades in the future. The accident report, the person who wrote it, the company that wrote it, doesn't agree with you, doesn't see it at all your way.
I understand that that's how STV saw it. I guess our position is simply that, you know, even if, for example, even if we concede the point that there was stacking, and we don't, but let's say we concede that point, our position is simply that the object, as the lower court found, was not the type of object that required securing or hoisting. In the cases that are cited by,
that isn't dispositive if it didn't require it. The fact is that it fell on this gentleman's head, back, and shoulder. I don't understand. It seems to me that you're grasping at straws here, especially because it appears to me that you're disputing the statement made by your own employee, Mr. Scarcella, who stated that it's improper for workers to work above or below each other, and his statement that tools should be tethered. So are you saying that Mr. Scarcella didn't know what he was talking about?
No, I'm certainly not saying that, but I think if we look at the cases cited in the brief where objects do fall that weren't required to be tethered, I think we see cases such as, you know, Moncayo, where the plaintiff was struck on the head with a piece of sheetrock that slipped from a coworker's hand, or the case of or Buckley, where the plaintiff was working in an elevator shaft and components of the moving mechanism fell from a height and struck the plaintiff on the head, or in Bancher, where the plaintiff was struck on the head by a falling water jug that fell off
Counsel,
a roof.
what about Henningham, which says that that falling object liability under 241 is not limited to cases in which the falling object was in the process of being hoisted or secured? Doesn't that run counter to what you're saying?
I would argue that it doesn't, just because, you know, just because an object falls doesn't necessarily mean that Labor Law 240 applies. And I understand there's some sort of, you know, there are the cases cited by the plaintiff in the First Department at Pato, Salcido, Albuquerque, Diaz. All of those cases, they're factually distinguishable on the grounds that the object that fell was not of the kind and character of the object that we're talking about here, which is a hand tool. There's no case in the First Department that finds that a falling of a hand tool necessarily implicates Labor Law 240. So I think
that actually, I'm sorry, counsel, it seems to me that actually hurts your case, because what's different about a hand tool like the wrench from the sheet from the sheet.
It was a sheetrock, and
I'm sorry, the sheetrock that fell on the other, is that it would be very easy to tether a hand tool. And in fact, all of your employees who testified, and all of Vestar's, Vestar's site manager, your construction project manager, all said that hand tools like this can be easily tethered and still quite usable. So it seems to me that you're really harming yourself by focusing on the difference between that and a piece of sheetrock, which admittedly couldn't be tethered in quite the same way.
I guess we rely on Mr. Temple's opinion that the hand tool could not be tethered and be rendered the same usable and movable.
So are you saying that the tether, which is shown on page 643 of the record, is not something to which a wrench can be attached?
I mean, perhaps it could be, but we don't know. I mean, it's all that's provided is a photograph of a purported hand tool tethered to a belt. I mean, there's no evidence here that that's something that was readily available, that anyone knew about.
Counsel, it seems that the expert was saying that the wrench wouldn't have been usable if it was secured or tethered on the parapet wall, which was the question I asked Mr. Isaac 10 minutes ago. nobody, they're not saying it should have been tethered onto the wall. It should have been tethered onto his belt so he could use it, but it wouldn't have fallen. I mean, that seems to be the big distinction here. Nobody's saying it should have been tethered to the wall. That's what the experts said. Okay, we've gone way over your time, so let's hear if your third-party defendant, Best Star counsel, you have 4 minutes. Mr. Buono, is that Buono? Yes, there you are. Okay, you may begin. Thank you.
Yes, thank you, Anthony Bono, for the respondent, Vestar Inc.
Thank you.
Frankly, I have nothing to add. I believe that there's the arguments raised by the plaintiff's attorney and by Mr. Meneses create a question of fact as to whether or not the work that was going on the roof constitutes a stacking of the trades, regardless of the accident reports that were prepared by individuals who did not necessarily witness what occurred in real time. Other than that, I will rest on the submission of my brief, and I will accept any questions that the panel may have. Thank you.
Does the panel have any question for Mr. Buono? Okay, then Mr. Isaac, thank you, Mr. Buono. Mr. Isaac, you have 2 minutes. Anything you'd like to respond to?
I just have 15 seconds, Judge Kapnick. If Mr. Bono's statement that there's a question of fact is present, then you have to reverse the order because my case was dismissed. Other than that, I'm willing to stand on my brief and my argument initially, if the court has no questions for me.
Any further questions, counselors, judges, panel? Okay, thank you all very much and have a nice afternoon. Thank you. Okay, the next case for argument is Capsuto versus Capsuto. Do we have Mr. Greenwald on behalf of the appellant? Mr. Greenwald, you may begin.
Thank you, Your Honor.
Good afternoon.
Good afternoon, Your Honors. I hope everyone is well. If it pleases the court, my name is Wayne Greenwald. I represent the defendant appellant Jacques Capsuto. This appeal is from an order that determined what the parties already did not dispute, that the parties' interest was a tenancy in common. What the order did not decide was what was prevented by the motion for summary judgment. How was the parties' interest in the shares in Washington, D.C. Studio Corp divided? Jacques Capsuto says that they are divided 53.5% to him and 46.5% to Samuel Capsuto. Samuel Capsuto's motion for summary judgment sought a determination that they were 50-50. The court.
So excuse me, so Mr. Greenwald, that's what the court said, is that, I mean, they granted summary judgment to Samuel Capsuto, and even though it didn't say in the order that it's in equal shares, that's what he moved on, and he was granted summary judgment on that. Is that correct?
It was granted summary judgment on that. It was tenants in common. However, the court did not consider all of the issues and the evidence concerning the distribution of the shares. That the motion and the cross motion had thousands of pages of documents showing that the interest in the property or the interest in the shares were disparate and pursuant to the amount that Mr. Jacques Capsuto says.
Now, did your client, Mr. Jacques Capsuto, produce any evidence, since this was a motion for summary judgment and you were required to lay bare your proof, to show that, in fact, you had contributed more money, which is what one of, I think, the main points that Jacques is saying. I'm sorry to call him by his first name, but since they both have the same last name, it's easier to do that. That, Jacques said, I produce more money. I know that the shares were issued a very long time ago, but did he have anything, in evidentiary form other than his own affidavit, which I believe is not appropriately signed?
Well, no, Your Honor, he doesn't. You can exclude his affidavit, but you can't exclude the testimony from his deposition, which confirms that the properties, that it's divided unequally and that he contributed more. And that fact is not is not disagreed with ever. Samuel Capsuto never disagrees with it. Never, nowhere.
I mean, that he put in extra money at the outset.
Right. He never disagrees that Jacques Capsuta put in more money. And in reality, that is also sufficient testimony to show a preponderance of evidence. Tamara A. versus Anthony Wayne, 974 New York sub 2nd 48, which is an opinion out of this court in 2013. So that testimony alone is enough to carry the day. That as far as the, we're talking about, he could not produce documents which he used to pay the money over 30 years ago.
Well, isn't that
Likewise,
also buttressed by the fact that Samuel accepted distributions which were less than 50%?
oh, yes. Samuel accepted distributions which were less than 50% up until this dispute resolved, up until the middle of this dispute, up until, I will say, in 2021 or 2020. So he's accepted less, and
counsel,
the
would
other
that be
brother
without
also,
Counsel, would
Albert,
that be without
accepted less as
objection?
well.
Counsel.
Yes, Judge Gonzalez, go ahead.
And
Forgive
with
me.
that, thank you. And was that without objection?
There was no objection ever, and nor was any presented. The only issue may have occurred in 2010 after Albert died. And we show a discussion in Aaron Gelbwax's office where Samuel is saying, I want more. I want to be equal with you. And Jacques says, hey, I contributed more money. That's why I have more. And Samuel never responded. So that's why Jacques has more. Likewise, the way that the parties operated basically dealt with the means of the income they received, which is the shares and the proprietary lease. They treated that income disparately along the shares that were discussed, the interest rates, the interest that we've discussed, unequal interests. And the documents, including all of the tax returns, which are included as exhibits, some of which are signed by Samuel, show that the interests are different. So that how...
Mr. Greenwald, I'm sorry to interrupt you, Judge Schulman. I have a question.
I saw you trying.
Is there a difference? And I don't want to sound like that this is sophistry. Is there a difference between the income generated from the operation of the restaurant, where which pseudo associates or the ST, I forgot the acronym of the restaurant,
SAJE.
where is well recognized that your client was the managing operator, and no one really disputes that those tax returns are referable to the income from the restaurant business, which unfortunately ended as a result of Sandy, as opposed to the value of the original 40 shares allocable to Washington Studio B, which the original stock certificate just lists them by name and doesn't break out their respective interest, percentage interest of the 40 shares. Do you recognize that there can be a difference?
I think I understand your question, and if I misunderstand it, you'll correct me, please. The income that the family received from the restaurant was generally their earnings, and that was separate income. There was income from the restaurant that was used to pay the proprietary lease, which was operated by Capsuto Associates. When the restaurant no longer operated, you had a tenant, which at the point was China Blue. There you're having the income went to the brothers, or at this point there were two brothers left. The income went to the brothers according to the proportions stated, which were 40, 46, and 53. So that you're looking at two different income streams. The income stream based upon the income from the property, being the lease and the shares of stock, were based upon those differences, based upon those percentages, 50, 53.5, and 46 and a half.
Okay, Mr. Greenwald, we've given you a couple extra minutes, so let's hear from Mr. Chinitz, and then we'll be happy to listen to you for a couple minutes afterwards, anything you have to respond. Thank you.
I appreciate that, Your Honor. Thank you.
Good afternoon, Mr. Chinitz. Whoops, we're not hearing you, Mr. Chinitz.
You're on mute.
I'm not sure if he's on mute or what, but I can't hear you. No, we can't hear you now. I can start talking now. Yeah. That's not working.
If I may, Mr. Chinitz, there's a lag between the point in time where you press the unmute button and the time when it takes effect. So if you press the unmute button a second, you leave it alone, we may be able to hear you. No.
Press the unmute button.
Is there any way we can accommodate Mr. Chinitz?
Well, yeah, I mean, he can call in, but, I got a lot of other cases on. We might have to put this sort of to the end so that we can move along, not make everybody else.
I would not object to that, Your Honor.
Mr. Chinitz, do you have a number to call in? You could try that. Otherwise, I'm going to have to put you at the end of the calendar. Okay, well, all right, talk. Still not.
He's still on.
We still don't hear you.
This might be him.
This might be him. Because it's looks like a cell phone number.
Can you hear me now?
Yes, now I can hear you.
I apologize for the technical problem.
Excuse me, Mr. Chinitz, if you would mute the sound on your computer, then there won't be an echo.
I will. May it please the court, my name is Stanley Chinitz. I represent Samuel Capsuto, and I ask the court to affirm the grant of summary judgment to Mr. Capsuto. The court only needs to determine whether the trial court overlooked any material evidence or didn't consider evidence in granting the motion. And the record will show that the court did consider the affidavit material, did consider the tax returns, and I would refer the court to the first paragraph of the decision.
Counsel, I'm glad. Counsel, I have a question. Counsel, I have a question.
Wait, Counsel, you have to let the judge ask the question.
Can you hear me,
Judge
Mr.
Gessner,
Chinitz?
go ahead.
I'm
Mr.
sorry?
Chinitz, can you hear me?
I can hear you. Can you hear
Good.
me?
Yes. Okay. I'm glad that you pointed to the evidence in the record, because what I don't understand is it seems to me that your position disregards the fact that after Albert's death, your client accepted 33% of the income and didn't object to, 46% of the income and didn't object to that. It seems to me that's powerful evidence that they owned it in a way other than 50-50, or he would have objected. So could you, first of all, it
Yes.
seems to me that the court might have disregarded that, but in any case, it seems to me very problematic for your position.
Justice Gessmer, there are two responses. The first is that all the parties incorrectly believed that the company Capsuto Associates held the shares. Now, Capsuto Associates LLC is the company that managed the restaurant. And there is no question that Capsuto Associates LLC, that Jacques was the owner of, or the majority owner of that. But in December, I misspoke, November of 2017, the shares were discovered, and it was discovered that Samuel owned 50% of the shares and that Jacques owned 50% of the shares.
Well, I don't understand
Because
how the stock certificate shows that. It simply says that they own the shares. It doesn't say anything about whether it's equal or unequal.
So
I don't understand how the stock certificate helps your case.
Let me say that EPTL 6-2.2A has a presumption that persons named on a co-op share certificate hold the co-op shares as tenants in common and implicitly equally, but that presumption can be overcome by a showing that one of them paid more for the shares than the other. And that is what—
Or perhaps a showing
Jacques
that one of them accepted a smaller amount of the income from that property.
What I would say, Your Honor, is that before Jacques Capsuto, let me rephrase that, before Samuel Capsuto discovered he was an equal shareholder, he accepted a lesser amount. When he discovered that he was an equal shareholder, he amended his complaint, and he did it promptly. And the second amended complaint alleged that he owned half, and he was entitled.
Counsel, if I may, this is Judge Gonzalez. So don't we need a trier of fact to decide all of this? There's so many questions that you're raising. There's so many questions that are unanswered, and you know that a court can take into consideration the amounts invested in a property in determining the shares to which that entity or person is entitled. Why is
May
it?
I respond?
Why, please? I don't understand why summary judgment is appropriate here.
All right. Two points, Your Honor. The quote evidence that Jacques relies on is incompetent, and he relies on tax returns from Capsuto Associates. Capsuto Associates never owned the shares.
I don't know if that makes the excuse me. I don't know if that makes the evidence incompetent, or you're just saying it might not be relevant. I don't know if it's incompetent.
All right. Well, I'll say that it isn't material. It's immaterial, and it doesn't prove anything, because if you look at those shares, there is nothing, or rather, in the tax return, there is nothing in the tax returns that show that the Capsuto brothers intended to purchase or own the Washington, D.C. shares unequally. Moreover, Capsuto, as I said, Capsuto Associates never held the Washington, D.C. shares. And so the trial court correctly decided that Jacques didn't provide proof for his claim that he paid more for the shares. And moreover,
why don't you just finish up?
Okay. So, Your Honor, the shares, there was no evidence that supports that Jacques paid more. The court noted that his affidavit was devoid of evidentiary support that was admissible. Let me see if I can quote what the court said. The court found that Jacques failed to provide any detail or proof that he paid more for his shares than Samuel. And so I think that is dispositive. But
all right, Mr. Chinnis, I've given you way more time than that we asked for. So I think we've got your point. I think all my colleagues have asked whatever questions they need to ask, and I'm just going to give Mr. Greenwald 2 minutes for rebuttal if there's anything you'd like to point out, and then we'll go back and take some more looks at these documents. Thank you, Mr. Chinnis.
Thank you very much. Number one, I think Judge Gonzalez hit the nail on the head. This deserves an evidentiary hearing. There are so many conflicting facts. There's so much evidence here that a trier of fact has to look at it all and hear testimony. That as far as the tax returns, they are not incompetent. They are circumstantial. They show what the parties intended as far as the interest from the stock. It shows how the parties intended the revenues to be, how the interests were divided. There's circumstantial evidence, and circumstantial evidence can be used to prove intent. And that is the case here, that Jacques Capsuto has shown that there were triable issues of fact, that his testimony of that he paid more is uncontroverted. Your Honor, I think I'm done.
Okay, you've given us a lot to think about, both of you. Thank you very much. Glad it all worked out. Have a nice afternoon. We're going to go on to the next case. Okay.
Thank you. We'll stay well.
Thank you both very much. The next case is Radium 2 Capital. Mr. Haspel.
Yes. Can you all hear me?
Yes. You may proceed.
May it please the court, my name is Joseph Haspel. I represent the appellants, Extreme National Maintenance and Doreen De Silva. The issue presented by this appeal is whether, in a contract case, a New York court can exercise personal jurisdiction over a person and a business, neither of which had any contacts with the state of New York. The factors to be considered are different for each appellant. With respect to Extreme, Radium 2 has attempted to create a jurisdictional link through allegations of successor liability. I absolutely remain at a loss as to the nature of the underlying facts supporting this claim. With respect to Doreen, there's a further degree of separation, specifically the more tenuous request of veil piercing through Extreme. The court should note that since the briefing of this case, there was a case called Lelchuk versus Société Générale de Banque out of the Eastern District of New York, discussing the issues presented in this case and holding New York courts have held that short of a merger, an asset acquisition is not sufficient to impute a target jurisdictional status of an acquirer. I have a Lexis site of this case. It's 2021 U.S. Disc Lexis 206270. That the court in that case goes through much of the same arguments that I discussed in my brief. While there are no issues of fact with respect to the lack of any contacts to New York by either appellant, there is no agreement as to the relationship between either appellant and the judgment debtor, all about maintenance. Each appellant maintains that there is no relationship whatsoever.
Well, of course, Mr. Haspel, I mean, obviously, we're at the beginning of the case. This is a 3211 motion. Might it not be appropriate to allow some form of jurisdictional discovery because the plaintiff has at least alleged enough? The plaintiff can't be in a position to know all these details at the time of rendering the complaint in terms of the potential de facto merger or alter ego claims that they're making.
Absolutely, Your Honor, and that was my position both to the trial, to the motion court, and stated in my brief and reply brief. The court should not have summarily made a determination without having jurisdictional discovery, and if necessary, a evidentiary hearing on the jurisdiction.
Counsel,
yes.
could you address the why there's jurisdiction over Doreen De Silva? How does the
I don't
court?
think there is any jurisdiction over Doreen De Silva, and in fact, the prior judge ruled that under the same facts. The Supreme Court, Orange County. Well, let me take one step back. The plaintiff, Radium 2, had brought on a petition under enforcement procedures in the Supreme Court, Orange County, and I moved to dismiss that, and the Supreme Court granted my motion to dismiss and indicated the jurisdictional infirmities in her decision. Instead of taking it back to the same court, Radium 2 filed a new action in New York, and they basically pleaded the boilerplate necessary allegations that Judge Bartlett indicated were deficient in the prior action. The boilerplate jurisdictional allegations were not supported by any facts other than facts stated upon information and belief, or again, boilerplate facts. For example,
Counsel, before you go on, Counsel, I have a question. Following up on Justice Gonzalez's question, am I correct that you would have no objection to jurisdictional discovery as to Doreen?
I believe that is the appropriate law because there's too many questions that exist. I have always indicated that if that were the decision, there would be no appeal because it would be appropriate to have jurisdictional discovery, but it was inappropriate to make conclusions that jurisdiction lies in this case where there are absolutely no contacts to the state. What's remarkable about this case is even the judgment debtor had no contacts to the state, except for the fact that there was a signature on a loan document which says that they consent to the jurisdiction of New York. This loan did not occur in New York. It did not. Nothing happened in New York except there was a document which was signed by the judgment debtor. That
okay,
was
Counsel,
not signed by,
all right. I'm going to stop you there. I'm going to let the other side speak for 5 minutes, and then you'll have 2 minutes of rebuttal. Thank you very much. Mr. Murray?
Yes, Your Honor. Christopher Murray, Stein Adler, Dabben, Zelkowitz for the respondent, Radium 2 Capital. Your Honor, there are a number of allegations in the pleading which deal with the issue of jurisdiction. All of the assets of the judge and debtor business were transferred to the respondent, Extreme National. All of the assets, and then it continued to operate the exact business. This is not a situation where it was a stranger, an arm's length transaction. Essentially, the business just continued in the name of a new entity owned by the judge and debtor's wife. We look very, very skeptically upon intra-family transfers. In fact, oftentimes the case law holds that in the context of an intra-family transfer such as this, the burdens of proof are reversed. So this is an incredibly skeptical transaction. In fact, it really does meet the archetype for a fraudulent conveyance. Counsel has said that this is a breach of contract case. This is actually a fraudulent conveyance case. The transferors are already judgment debtors. The transferees are in fact in possession of and running the business of the judgment debtors. The testimony or the affidavit that my client submitted, which was a verified pleading, it sets forth a number of factual grounds, including the transfer of all assets. Counsel hangs his hat on a handful of what he calls vaguer allegations, but then ignores the more specific allegations, talking about the continuity of the business, talking about the fact that customers have raised the same point. We seem to have the same position that everyone, or same impression that everyone else has taken, that this is a fraudulent transfer and that they've just continued the business in a new name.
Counsel, I have a question, because in the brief, you really don't address the defendant, Doreen. Everything is about Extreme, and you talk about the defendants together, but what is your specific argument that it's appropriate to assert personal jurisdiction as against Doreen De Silva?
Your Honor, we would agree with the trial court that she engaged in activity that she knew was going to cause a harm to us in New York, and this is a fraudulent transfer, and she did harm us in New York. It's something that we have agreed. We need jurisdictional discovery on. My adversary has actually said that he has always agreed that we need jurisdictional discovery. Since then, we've been trying to get discovery on the very issue of jurisdiction. The trial court hasn't actually ruled out the possibility that this might be an issue that gets renewed. And we have been trying to get discovery from them. We've received, for the most part, objections on the issue of discovery by the respondent. So I'm very, I find it very difficult to reconcile counsel's arguments with what is taking place in the trial court. The trial court didn't rule out the possibility of a renewal. And in fact, the ruling is that petitioner has thus pled its causes of action and jurisdiction. That's the initial burden to get to jurisdictional discovery. So it seems like everyone agrees that jurisdictional discovery is where we're supposed to be at this stage, except for appellant's brief, because even in their reply brief, they then go and suggest, well, jurisdictional discovery would be appropriate. We've met that threshold for jurisdictional discovery. I think everyone agrees to that effect. To the extent that they suggest that, well, perhaps the court should have dismissed the case for lack of jurisdiction, I don't think the court could have done that, because the only thing they actually submitted was an affidavit consisting of legal conclusions by Doreen De Silva. And we're not talking about substantial allegations. She basically just repeats a handful of legal conclusions, asserts them as facts, and that's it. That's not sufficient to establish a lack of personal jurisdiction, and it wasn't sufficient to prevail on their motion. So in that regard, they didn't meet their burden for conclusively rejecting the court's jurisdiction. There is one thing I would point out with regard to the individuals. It's in the contract terms themselves, which we fought to have included in the record, which the court agreed should have been included in the record. It was that successors and assignees are bound by the same jurisdictional provisions as the entity, the judgment debtors. This is something that is relevant. It's something that's particularly relevant in this particular case. And given the fact that they purported to bind their successors and assignees, I think that this is a straightforward case where if they want to go ahead and continue, we do have to continue with jurisdictional discovery. It seems to be straightforward.
Okay, anyone else have any further questions for Mr. Murray? Okay, thank you very much, Mr. Murray. Mr. Haspel, you have 2 minutes for any rebuttal.
Yes, once again, counsel for respondent makes the conclusion that all the assets were transferred. Yet there's never been an allegation of what the assets were. This is an entity which purportedly purchases receivables, yet not a single receivable that it purchased is alleged to have been transferred to Extreme. There's no allegation that that equipment was transferred to Extreme. There is no allegation of anything other than the boilerplate, all assets were transferred. How were they transferred? They weren't transferred by a sale, and they were, and there's no indication that they were transferred at all, because there's no indication of what assets we're referring to. I just want to make a point that with respect to the de facto merger allegations that have been made conclusively, there's no question under New York law and in this court's case law, which provides that a successor corporate liability based upon de facto merger is inapplicable in an action to collect on a promissory note. That's exactly what we have here. This case, this court's case was Simbax against Bingaman, 219, Appellate Division 2nd, 552, 1995. They're trying to create successor corporate liability based upon de facto merger in a case that's based upon a promissory note. They can't do it under this court's prior ruling.
Okay.
Unless there's any questions.
Is there any other questions? Okay, thank you both very, very much. We'll take a further look at this. Thank you for the arguments and for coming in today.
Thank you, Your Honor.
Okay. The next case for argument is grocery delivery versus Flynn. Counsel, you may begin.
Good afternoon, Your Honors. Anthony Carlini on behalf of the appellant. May it please the court. The set of facts now before the court are not uncommon. Here, HelloFresh claims that Mariner Seafood, a non-party to this case, received monies in the form of insurance proceeds, which it had an interest in and which was not paid over to it. While such claims often support a breach of contract claim, this court has consistently held that it does not, those facts do not support a conversion claim. And I refer to the MD Carlisle case decided by this court in 2008, the 2001 case of Kurzman and Carlson, the 1998 case of Interstate Adjusters.
Yeah, but sir, we're dealing, this is Judge Shulman, aren't we dealing with identifiable funds where the plaintiff arguably has an equitable lien on those funds as opposed to a straight breach of contract case?
Well, that's exactly what HelloFresh tries to argue in this case, since it cannot meet the element of ownership, control, or possession. It did not own the funds. It was not a named insured on the policy. It never had possession or control of the funds. So it claims it has an equitable lien on the proceeds. And that certainly does not stand up under the Court of Appeals decision in the Teichman case. And in that case, the court held that in order to have an equitable interest, you must review the agreement, and the agreement must have three things. It must have an agreement to give a lien, which is not present here in this record. The parties must specifically identify the property that will be subject to the lien. And the agreement must indicate, and I'll quote the Court of Appeals, with sufficient clearness and intent that the property be held as security for the obligation. None of those facts exist in this case. We have the agreement. It's part of the record at page 23 through 38. It's the only agreement between the parties. The only thing we have here in the agreement is a generic requirement to have insurance, whether it be liability, whether it be motor vehicle, as well as a requirement to reimburse HelloFresh if there's a product recall. There's no tying of the two. There's no indication that a specific fund will be set up, which this court has repeatedly required in the MD Carlisle case and the Kurzman-Carlson case. There's no indication that there was an assignment of those insurance funds. You would have to see that in the agreement in the record.
Oh, wait a second. You know, I'm listening to you. I mean, the agreement, The agreement said that you would carry product recall insurance. I mean, not automobile insurance, product recall insurance, and that plaintiff would be named as an additional insured under the policy. And you didn't name them as an additional insured under the policy, so you had to make the claim instead of plaintiff making the claim. You got the money for the recall that caused them damage, and you didn't give it to them. I mean, I don't get your argument here.
Sure, and I'll address that. There have been facts that support conversion, which are stronger than what we have in this case, where this court has refused and has dismissed conversion. I'll refer to the MD Carlisle case. In that case, this court had before it a defendant who was collecting utility payments on behalf of the plaintiff. Certainly, the plaintiff had an interest. It stated in the agreement that it was collecting it on behalf of the plaintiff, and the defendant never paid them over, filed bankruptcy, and this court dismissed conversion. Said, yes, you have a breach of contract, but you do not have a conversion claim. Similarly, in the Kurzman-Carlson case, that was a case regarding an attorney who agreed with another attorney that in the event there would be a settlement, he would split those proceeds with the other firm. The settlement.
But counsel, this is Judge Gonzalez. Let's look at the alleged facts here. So the plaintiff filed an insurance claim with Tokyo Insurance after there was a product recall, right?
Yes.
But the plaintiff was prevented from recovering directly from the insurance company because the defendant did not add it as an additional insured as required by the service level agreement. So the funds were disbursed by Tokyo or by
Tokyo Marine
in the amount of $236,000 and change. And Mariner's position, correct me if I'm wrong, is that because it's named on the insurance policy, the proceeds were properly paid to Mariner's general corporate account?
Mariner's not a party.
Is that where we're going here?
Well, Mariner's not a party to this action. Mariner is sued in the separate action for breach of contract.
So Mr. Flynn, let's talk about Mr. Flynn, who's sole member of manager and sole member of Mariner. So he's the one who's sued, right?
That's correct.
His company. So his company kept all the money, and because he's an officer, and he's a person liable for acts which bring about a conversion of a third person's property, right? So what are we doing here? Who suffered the product recall?
HelloFresh suffered the product recall.
But you can keep the money?
What this court has said, Your Honor, is that no, Mariner should not be able to keep the money. That was a breach of contract. It was a breach of contract not to name HelloFresh as a named insured, and perhaps a breach of contract not to turn over the money. But we're talking about the principle, and what this court has said is that you have to look behind that and look at the record. Was there any agreement that there would be a lien on these proceeds? The answer to that is no. Was there any assignment of those insurance proceeds in the agreement? The answer to that is no. And
so if you didn't suffer the product recall, you get a freebie, you get a windfall, because the insurance company paid Mariner, Mr. Flynn's company, for HelloFresh's loss?
That's exactly what this court has said, Your Honor.
This court hasn't said anything yet. We haven't said anything.
In the past, in terms understood, Your Honors. In the past precedent, MB Carlisle, Kurzman-Carlson, independent. It has always said that yes, there may be a breach of contract, and that may be the recourse, but it doesn't extend further to conversion unless you have these other elements.
Okay, counsel, I've given you a lot of extra time, so we're going to have to stop. I'm going to hear from the respondent, and you'll have 2 minutes for rebuttal. Thank you. Respondent.
May I please support? Can you hear me?
Yep, we can.
Michael B. Smith, Lupkin PLLC, for the plaintiff respondent, HelloFresh. It seems to me from the questions that the panel gets it, so I'll try to be brief. There are just a couple points I want to hit. The fundamental flaw in the premise of all of Mr. Flynn's arguments is that this was a contract to pay insurance proceeds when they were received. That's not what this was. This was an assignment. This was an entitlement. This was HelloFresh, or rather Mariner, promising to make HelloFresh a direct beneficiary of the insurance proceeds. And when they didn't do that, we got an equitable lien. And that's clear. That's the holding in Rosario Paulo from the Court of Appeals, and that's the holding of this court in Bank of India. And that distinction was noted by the Court of Appeals in Leon when they noted specifically the distinction between saying, I will pay you X when I get the money, where there is no lien, where there is no possessory interest. And you are entitled to X, where there is a lien. And this is an entitlement. This is Mariner saying to us, you're entitled to the insurance proceeds. Mr. Flynn, like the child who kills his parents and then pleads sympathy because he's an orphan, didn't make us an additional insured, kept the money, put himself in between us and the insurance company, and now says, well, we're the named insured, so we get to keep the money. That, respectfully, that is just not the law. I think I'll end there unless the court has any questions.
Anyone have any questions? Okay, thank you very much, Mr. Smith. Mr. Carlini, you have 2 minutes.
Thank you, Your Honor. Counsel has referred to the case of Rosario Paulo, the Court of Appeals case, and Bank of India, which was decided by this court. I would like to point out that both of those cases upheld conversion for a specific reason. In both of those cases, there was a specific security agreement, a written security agreement, that secured the insurance proceeds as collateral for whatever loss that was sustained. And I'd ask the court to review that. There was this, and that's why in those cases, and those are distinguishable from here. Here, there is no security agreement. There is no agreement that a lien would be given on the insurance proceeds.
But counsel, counsel, I have a question.
Yes.
Do you dispute Mr. Smith's argument that that Mariner's failure to name HelloFresh as an additional insured imposed an equitable lien on the asset?
I would dispute that because I have not seen any precedent that says that. I have not seen that, and it has not been argued.
What about the Rosario case?
The Rosario case says that if you have a security agreement, a written security agreement, which is different than this case. In Rosario, there was a security agreement, an agreement to put the insurance proceeds in trust. Here, we do not have those facts. It is a very different case.
So do you think there's no implication? Nothing flows from Mariner's failure to get the insurance it was required to get?
Perhaps there is, but it should be against Mariner, and it should be in the form of breach of contract. It shouldn't be against our client. And additionally, a point I haven't raised was this court, again, has repeatedly dismissed claims, conversion claims, where they're duplicative of a breach of contract claim. So, and here, there's no independent duty that they've pointed to, that HelloFresh has pointed to, other than the breach of contract. There was no duty of my client to safeguard or as a bailee or anything of that nature. And for those reasons, we think the lower court should be reversed.
Okay, thank you both very much for your arguments. We appreciate it. Have a nice afternoon.
Thank you.
Okay, the next case for argument is a 517, no, SHG Resources is the next one. Sorry about that.
Good afternoon, Your Honor. Can you hear me?
Yes, we can. You may proceed.
Ephraim Schwab on behalf of the appellant. The court below obviously granted summary judgment on behalf of the plaintiff, and we made 3 arguments why we believe the decision of the trial court was wrong. The first one's a technical argument. The technical argument is that we hadn't answered the complaint. And since we hadn't answered the complaint, the CPLR says in 3212A that you can't move for summary judgment until after issue has been joined. Now,
but there are exceptions to that, are there not?
Correct. There are exceptions, and I want to discuss 2 of those exceptions just very briefly. The first, the plaintiff argued that there are 2 exceptions. The first exception that they argued was that we charted a path of summary judgment. The defendant did not chart a path of summary judgment. The plaintiff moved to dismiss based on jurisdiction and based on necessary party. They responded with a summary judgment motion, and then we opposed the summary judgment motion. I can't believe that that's called charting a path of summary judgment, because it would mean that any time that a party makes a summary judgment motion that you have to lay down. Otherwise, every case is a case of charting a path of summary judgment unless you just don't respond to the summary judgment motion. That is not what the courts and the First Department means when they say charting a path of summary judgment, because then this rule would disappear. The second exception that they argued, and I think it was tucked in, I didn't notice it until I was rereading the papers, is they claim that this case is an action that only involves issues of law. And there's an exception that if it only involves issues of law, then that's an exception where you don't have to wait for the answer. I just want to note, I don't believe this is a case that involves an action that just involves issues of law. And I believe what the argument is going to be is, well, the judge believed that you can interpret the contract, that there's a plain meaning to this contract and it's not ambiguous, and therefore there are only issues of law. But that is not what the First Department has held complies with this exception. There was a recent decision in 2020, Brower versus Lepore, which is cited in our brief, where the case involved specifically the interpretation of a contract, and the court said that summary judgment was improper because the answer hadn't been filed. Once the answer was filed, then you could move to summary judgment, and renewing and re-argue would be appropriate there, and summary judgment should have been granted. But in this case, no answer has been filed. So this is a case that involves facts. So that exception we don't believe applies. So that's the response on the technical argument. On the second argument we made was that the contract's ambiguous. Now, obviously, Justice Sherwood disagreed. He said it wasn't ambiguous. And I've spent a lot of time reading this Section 8 of the note, which in order for there to be a guarantee, there has to be liability under the note. Justice Sherwood focused on the third paragraph of Section 8. And we believe that there's a contradiction between the first paragraph and the third paragraph. They both refer to an April 1 date, April 1, 2019 date, and then a process starts. And then at the end, it says, if you don't consummate by April 1st, then you don't cancel the debt. But the beginning talks about giving.
In this case, Counselor, you sent out some type of notice around March 28th, I believe, but nothing obviously was consummated or completed by April 1st.
Right, and we couldn't consummate because we had to give them 30 days to decide whether they were going to. They had a right of first refusal, so we put the process.
So it seems to me you had to do it 30 days before April 1st. Otherwise you're in violation of the Section 8.
It's all part of Section 8. It all reads straight. And the problem here is the reason why I believe there's an ambiguity, and I spent a lot of time, again, reading it over, is because the first paragraph means nothing if we weren't allowed to give the transfer notice before April 1st, 2019, even though the 30 days continued, there would be no purpose to the April 1st date in the first paragraph if we couldn't continue to consummate the deal 30 days later when the right of first refusal went out.
This is Judge Gonzalez, but wasn't the submission of that notice in your power to control? It was your notice, and ultimately the notice didn't even have a commencement date for the proposed lease, which was required pursuant to the agreement. So where do you end up?
I mean, they're not arguing about on this appeal. They don't argue about the defects in the notice. They don't want to go there because there are factual issues with respect to the notice, and that'll be a factual issue. But
your basic issue is procedural, right? You can't make a pre-answer motion for summary judgment.
Well, that's clearly answer one, but I really do believe that this section is ambiguous. And I just want to note one thing. The reason why the plaintiff—
That's all you can note because the time's up.
Okay.
One thing.
Plaintiff says, thank you very much. I'm sorry for taking too much time.
That's okay.
Plaintiff says that the reason why it's not ambiguous is because the right of first refusal still existed if you gave notice before April 1st, and therefore the first paragraph doesn't disappear. It's not meaningless. The answer to that is the right of first refusal in section 2, not section 2, but the second paragraph exists forever. They always have that right of first refusal. The April 1st date, there's a contradiction between the first paragraph and the third paragraph. It is ambiguous, parole evidence is relevant, and summary judgment shouldn't have been granted.
Okay, we're going to hear from the respondent, and then you will have 2 minutes to rebut. Okay, Mr. Steiner?
Yes, thank you, Your Honor. Neil Steiner for the plaintiff. May I proceed?
Yes, please.
Thank you. So I'll address the argument. I'll address the procedural argument first to the extent the court has questions, but I think that this case squarely falls within the exception set out in the Four Seasons case by the First Department for when a motion for summary judgment is proper. I think New York law is clear that interpretation of an unambiguous contract is a matter of law. We submit, and Justice Sherwood obviously agreed, that this contract is unambiguous. We complied with the procedures for cross-moving for summary judgment. We served a Commercial Division 19A statement. They admitted in response to that the key facts, that there was no consummation of a transaction, there was no lender acceptance. They didn't identify any areas of discovery that they thought made summary judgment premature, that there was something that they needed. And Justice Sherwood, I think, properly treated this as an issue that he could rule on based on the plain language of the contract, and that's appropriate for summary judgment. With respect to—
How did both sides, just a question, Counselor, how did both sides make it unequivocally clear, like Four Seasons requires, that they're laying bare their proof and deliberately charting a summary judgment course?
Well, Your Honor, I think there's two things. One, part of Four Seasons says if it's an issue of law, there they said if it's an issue of statutory construction, I would say contract construction is the same thing. If it's if it's applying an unambiguous contract, that's an exception that Four Seasons recognizes.
Yeah, but there's a few different, you have to fill, there's a few elements that you have to meet, and this is one of them.
I think they're actually all— Sorry, Your Honor, I didn't mean to be—
No, go ahead. Go ahead.
I think they're actually alternatives that— I think there are 3 or 4 alternatives that Four Seasons lays out. One of them, if it's a question of law, the example that Four Seasons uses is the interpretation of a clear statute. I think a clear and unambiguous contract would fall into that same exception. Another alternative is if the parties make clear that it's being treated as summary judgment. Here, we served a 19A statement. Defendants responded with a response to the 19A statement. They didn't respond with identifying any discovery that they thought made consideration of summary judgment premature or inappropriate. And we had argument on it in front of Justice Sherwood, who advised the parties he was considering the arguments. So I think that's, as to the question of whether or not this contract is unambiguous, I think is a legal question that clearly Justice Sherwood properly considered. And then turning to the contract itself, there's no inconsistency or contradiction in the terms, right? There are some provisions of Section 8 that provide my client with the right of first refusal. And that's in the event that there's proposed to be a transfer prior to April 1st, they have to comply with the notice provisions. And then there's a provision that says they could get, for their benefit, they could get a reduction if they consummate a transaction by April 1st. That provision uses the difference between consummating a transaction and delivering a notice probably dozens of times. It's pages 24 and 25 of the record. It's section 8 of the note. It clearly distinguishes whether it's talking about delivering a notice or consummating a transaction. And here the first prong says consummate a transaction. There's no dispute that they didn't consummate a transaction. There's no argument that either of the other two prongs apply. And so there's no dispute that they don't get the waiver of this or the note reduction of this provision. And then the last thing I'll touch on, I think it's clear in the papers, but the jurisdiction, the question of a necessary party or jurisdiction over the guarantor, I think is, Mr. Schwab didn't touch on it. I think it's frankly a frivolous argument. The guarantee says you don't have to pursue remedies under the note. It's a standard note guarantee. It's signed by the individual who controls the LLC. He clearly consents to New York jurisdiction, in all caps in the note guarantee. I just don't see that argument at all, but I'm happy to answer questions if the court has any.
Anyone have questions? Okay, thank you very much, Mr. Steiner.
Thank you.
Mr. Schwab, you have 2 minutes.
Thank you. So the first exception to the technical rule is that if the action involves no issues of fact. This action clearly involves issues of fact. The fact that Justice Sherwood believed that it was an unambiguous contract does not qualify for that. That is the Broward decision from 2020 that's in our papers. That's what the court said, that even though it was an unambiguous contract, that's what it clearly is written there. That wasn't sufficient. On the issue of did we advance, did we chart a course of summary judgment? We objected to summary judgment. We said you can't move for summary judgment. The plaintiff jumped the gun, and that's the law. The CPLR.
I'm sorry. What effect, if any, did it have, which I believe Mr. Steiner brought up, that you both filed those 19A statements, having been in the commercial division? I thought you did that only with summary judgment motions. No?
Yeah, well, they moved for summary judgment. If we would not have filed a 19A statement, we would have been deemed to have admitted every single thing. You have the party responding to a summary judgment has to respond to it. Otherwise, they're going to lose, de facto.
Just on that purpose.
Exactly. That's not charting a course. And finally, on the ambiguity, again, the April 1st date, when you read the whole provision, it certainly makes you think something is wrong here. There's an April 1st date at the beginning, there's an April 1st date at the end, and the concept that the right of first refusal would applies to that original April 1st date is wrong. It doesn't apply to that date. The right of first refusal applies no matter what. So that April 1st date should have allowed us to have the opportunity to consummate the transaction and finish it up. And that's my argument. Thank you very much.
Judge Gesmer, did you have a question?
I'm good. I'm all right.
You're okay?
Thanks.
Anybody else? All right. Thank you both very much. Have a good afternoon. Thank you. The next case is 517-527 West. Appellant?
That's me. For the appellant.
Okay. Ms. Melman?
Yes, Your Honor.
All right. Good afternoon. You may begin.
Yes, this is an appeal from judgment of strict foreclosure and the underlying order, which dismissed the defendant's statute of limitations defense. The court determined that the statute of limitations did not run out 6 years from the commencement of the foreclosure action, but that it ran anew at the time of the foreclosure sale. And that is not correct, because in a foreclosure proceeding, the statute of limitation runs when you file your action or at maturity, and then it runs throughout the period of the action, and that would be 6 years. So this action, the underlying foreclosure.
But the thing is, excuse me, I have a question. I mean, this is an unusual situation. It's a strict foreclosure action, which I have to admit, I really had very little familiarity with before I read about this case. So this is something that the actual strict foreclosure proceeding could not possibly have commenced until the sale of the property in an underlying foreclosure sale. Otherwise, the issue involved in the strict foreclosure would not have reared its head. So how could the statute of limitations start running from the beginning of a foreclosure action? It doesn't even make sense to me.
Because it's a post-judgment remedy. It is not a statute of limitations that runs anew. And the court.
But how could the statute of limitations on the post-judgment remedy start years and years before the judgment?
Because, Your Honor, when you compare strict foreclosure to re-foreclosure, Article 15 at section 1503 clearly says that in re-foreclosure, you can bring an action even though it would be barred by way of the foreclosure proceeding. There is a statute of limitations that runs from the commencement of the foreclosure. It runs for 6 years. And in this case, they had gotten to judgment in 2014. They had.
Excuse me, counsel, the provision you're referring to doesn't talk about strict foreclosure. It talks about re-foreclosure.
Yes, but strict foreclosure.
Wait. Let Judge Gismer finish her question.
Strict foreclosure only lies if there's a defect in the judgment. So I don't see how you could possibly have the statute of limitations start to run until the defective judgment is issued at the earliest, or more likely at the sale pursuant to the defective judgment. I mean, I think there's no question here that that in the initial action, the judgment was defective and not terminating everybody's interest. So it's at that point where the judgment failed to do that the cause of action arises, not before that. There's no cause of action before. I don't understand how the section you're citing has any relevance to this situation.
Because in strict foreclosure, you have to conclude your proceeding, and it's not until the point that you get to a sale, and you're correct, that you would determine at some point that you didn't name a lienor. They had the opportunity. They knew before the sale that they didn't name the defendant, but they didn't do anything about it. They conducted the sale, and they waited another 15 months before they started this action. There comes a point where there's a bar. You cannot keep running up interest and accruals. There is a bar, and
what creates, counsel, I hear you, but what creates that bar?
Okay, what creates it is the election of remedies, which is to commence the foreclosure action. And I just would like to read to you RPAPL 1503, which says that there is a statute of limitations, and 1503 says that when real property has been sold pursuant to a judgment in an action to foreclose a mortgage under Article 13 of this chapter, or pursuant to Article 14, or has been conveyed to mortgagee, such mortgagee, and it appears from the records such action that basically it allows for re-foreclosure under 1503.
But again, not to beat a dead horse, but this isn't a re-foreclosure action, and that statute is not what we're applying here. We're doing RPAPL 1352 under strict foreclosure. So that's a different, a re-foreclosure is a different whole action proceeding, no?
It's not in the sense that, first of all, this plaintiff has referred to 1501. It's trying to mingle the actions. And normally when courts deal with the difference between the two, they must be distinguished. And that was not done here, which is that under 1352, it is a remedy when you have not named someone. But it doesn't run another 6 years. It would be improper for to say that you can charge the lienor 12 years of interest, penalties, note onto the note and mortgage. That makes no sense.
Well, of course, we're going to end here, but that is that's like a second argument, and that's being dealt with, I believe, before a referee. So
Well,
we didn't even get that. Maybe, those arguments have to be made before the referee if you get there. Let's listen to Mr. Blumenthal, and then you have 2 minutes to respond to him, Ms. Millman, okay?
Oh.
Thank you. Mr. Blumenthal?
Thank you. Thank you, Your Honors. Dan Blumenthal, I'm here on behalf of the plaintiff respondents, 517-525 West 45th Street. Essentially, I think where the confusion lies is somewhat in history. In the papers, you'll see references to both strict foreclosure and re-foreclosure being harsh remedies. And prior to the RPAPL, they were, because they would compel a new judgment of foreclosure and sale for the unnamed lienor. In fact, the section of RPAPL 15, which was cited regarding statute of limitations, the origins of that were in RPL 501A prior to 1963. And that applied to both because at that point, both had that remedy of a judgment of foreclosure. Essentially,
that's no longer the remedy here under this section.
Yes. All this case is about is setting a right of redemption. And it may well be a case of first impression. The only case that talks about strict foreclosure redemption, it's been cited in both papers, is the Quaremba decision, Quaremba versus Nassau Suffolk Lumber. And that case was decided under the prior statutes. It was decided in 1959 by a Suffolk County Supreme Court justice. The statute at that time did have similar language, but all that came out to be was a judge making his decision in these proceedings, which are decided foreclosures are equitable proceedings, and that judge made a determination as to what items were essential to be for the redemption. That's all we're asking for here. I would note also that Quaremba does also set forth a secondary remedy for the purchaser at foreclosure to simply pay off the amounts due on that initial mortgage. The amounts that can be proven on that mortgage and sort of flip the script, if you will. The bottom line is that this was discovered. There is a question as to when it was discovered. If you look at, I believe it's Record 91, it's one of the affidavits from one of the principals of 517. They discovered this in late summer or early fall of 2014. The sale was early in the summer of 2014. It was after the sale. So, and that is that.
Well, so are you saying that this junior mortgage on the property that was held by Mr. Avrahami was not filed, was not recorded? I mean, how did you not know about it?
It was of record. My client was not the original foreclosure plaintiff. They essentially purchased the interest of Mercury Capital at the judgment phase, somewhere just after the judgment phase, and thus became the plaintiff and the bidder at the foreclosure sale. And what they took was a property that was encumbered by multiple problems. It is in a special development district. It is covered by the loft law, and it is covered by HPD. There were multiple violations. They could not get a certificate of no harassment because there was a finding that Mr. Avrahami, as manager for the prior owner, Shabbat LLC, had harassed tenants in the building. So they were compelled to do the work. Meantime, Mr. Avrahami, and it's within the record, evaded service. It was determined that he did so intentionally in the strict foreclosure proceeding, delaying that proceeding. As I said, these are actions in equity. And I believe a review of the record will show that equitably my client is entitled to proceed with the reference. That portion is not yet before this court. It's in front of the referee. He is taking a broad range of evidence. and he will determine what he believes the law says as to what is what should be awarded my client as the right of redemption.
And then we'll have another appeal. No,
It's,
but it's
I hope not, but yes.
premature now is your position, correct?
Yes, yes, it is.
Okay. Do any of my colleagues have any questions for Mr. Blumenthal? Okay, thank you. Ms. Millman, you have 2 minutes to respond. Thank you.
Okay. First of all, at page 17 of the record of the complaint that was verified, you know, they knew about the error in not naming Mr. Abrahami before the sale. They went ahead with the sale. They delayed another year, and meanwhile, they started their efforts before the Lofberg board. Mr. Abrahami was strictly a property manager. He was not involved with a harassment that went back to 1994 with regard to a kennel, other things that were going on here. All of the facts regarding what went on before the loft board is not in the record. So to disparage Mr. Abrahami is not proper. Mr. Abrahami had a valid mortgage. At page 129 of the record, his attorney commenced an action and said that as of July 28th of 2008, he was owed a debt, and that in exchange for the debt, they reaffirmed it and they put a mortgage on the property. So the real issue here is the prejudicial delay. The plaintiff took the time to first go before the loft board, and now he's seeking over tens of millions of dollars for improvements that are only permitted in a reforeclosure. So the plaintiff is making this into who did what, when this is strictly a right of redemption that's been prejudiced by the delay in not beginning the action. And now they're saying that my client delayed with the service. My client was served within 50 days of the commencement of the action. The referee went far beyond the scope.
Okay, but I mean, that we don't even have a decision from the referee at this point. So I mean, I think that might be a little bit premature, that point on the appeal, but the statute of limitations obviously is something we have to deal with.
Well, Your Honor, if I may, I'd like to bring to the court's attention Daldan Inc. versus Deutsche Bank, 137 New York Sup 3rd 407. And it states clearly that in the context of a foreclosure action, the statute of limitations begins, it continues to run, and there is nothing that counsel has referred to other than some sweeping argument that the statute of limitations runs anew. It does not. You cannot collect 12 years of interest and penalties.
Okay. I think we got all the arguments that you've made. We will take another look at these cases,
Please, Your Honor.
papers. Thank you both very, very much.
Thank you very much.
Have a lovely day, rest of the day or evening. Okay, as I look up and it's starting to get dark. The next case for argument is People versus Kevin Day. Ms. Namorin?
Yes, Happy New Year's to the Lord. Can I start, Your Honor? I'm so sorry.
Yes, you may. Go right ahead. Thank you. I just want to make sure I got your name right. Thank you.
No problem. So yes, Happy New Year's to Lornie Namorin for appellant Kevin Day. The guidelines taken as a whole make clear that even as to misdemeanors, the conviction must predate the commission of the sex offense to be considered criminal history under Factor 9. Respondents' argument narrowly focuses on 2 pages of the guidelines because under page 13 and 14 of the guidelines, when describing the 3 layers of points under Factor 9, one being 30 points for violent felonies, the word conviction or adjudication is used to describe those violent felonies. The word conviction or adjudication is also used for 15 points as to other felonies. Then there's 5 points for any criminal history. However, Your Honors, the guidelines in Part A, paragraph 10, describes what does criminal history mean. The criminal history portion of the risk assessment instrument focuses on the offender's prior crimes. Crimes include conviction, youthful offender adjudication.
So, counsel, this is Judge Gonzalez. So I'm looking at priors, and the bike robbery with the knife was May 24th, 1986, and the rape with the broken bottle was May 31st, 1986. Why? Is there a, how does that factor into your argument?
So, Your Honor, crimes are not merely the arrest. So yes, Your Honor, March 1986, there was the arrest for the prior misdemeanor. In May 1986, there was the commission of the sex offense, but the conviction as to the prior misdemeanor happened in September 1986, Your Honor. The guidelines state that arrest, the fact that an offender was arrested or indicted for an offense, is not by itself evidence that the offense occurred, Your Honor. Also, Your Honor, I want to highlight on page 6 of the guideline, footnote 6 says, although an adjudication as a youthful offender is not a conviction, it constitutes a reliable determination that the offender committed the underlying criminal conduct. So, Your Honor, yes, the arrest for the misdemeanor did happen prior to the commission of the sex offense, but the arrest alone in and of itself is not a reliable determination that the offender committed the crime. That reliable determination happens once he pled guilty, which is September 1986, which came subsequent to the commission of the sex offense, Your Honor.
Counsel, this is Judge Shulman. I have a question. But wasn't his conviction for the sex offense after his conviction for the misdemeanor in September of 2006?
Yes, Your Honor. So,
okay, and when you analyze factor 9, I think it's factor 9.
Yes.
It ranges from 5 points to the 30 points, 5 points being just for criminal history, whereas the higher points are for convictions. So that wouldn't it be enough to rely on a criminal history, i.e. the March crime for taking the bicycle, I think, and then later, which was validated. It was validated, and it was all validated before the actual conviction of the sex offense, which allowed the court to consider, which eventually led to the evaluation on ERAI. So do you have a different understanding of the 5 points?
Yes, Your Honor. So I think one, it's as to what does crime mean? And I think the guidelines in Part A, which is the general principle, creates a parameter as to what can be considered crimes, Your Honor. And what I am stating is that the arrest, which did happen prior to the sex offense, was not considered a crime. Now, as to the sex offense conviction, which, yes, Your Honor, he was convicted for the misdemeanor prior to the conviction, Your Honor, but the sex offense conviction date is not something that the guidelines utilize as an important date or this court. So there is no case that is directly on point as to misdemeanors, right? This 5 points you discussed, which is different than the 30 points. But this court in People v. Franco does address factor 9. And I think in the dictum of that case, there's some instructions on how to apply misdemeanors. So in that case, this court tells that a conviction is when a defendant pleads guilty or a guilty verdict is entered, not when judgment happens. Then the court says, as long as that date happened prior to the commission of the sex offense, the point should be assessed. So the date of conviction of the sex offense is not something discussed in the guidelines or discussed in dictum in this court or the 3rd or 4th department, which also have addressed factor 9. Yes, I understand, Your Honor, you bring up another thing, which is that the difference in points. 30 points, I think you're suggesting has a higher threshold, and 5 points may have a lower threshold. But Your Honor, there's nothing in the guidelines or in past dictum to suggest that, Your Honor. And the 5 points do make a difference. So in this case, the 5 points is the difference between a level 2 and a level 3. I don't see any evidence in the guidelines or any statutory dictum, case law dictum, to support that 5 points has a different level of sequence than the 30 points.
Okay, counsel, thank you for your argument. You'll have a minute or so to rebut after we hear from the people. Thank you. Mr. Walkowitz?
Good evening, Your Honors. Happy New Year. First, I just think counsel makes the point about the guidelines. There are different things in different sections, but factor 9 is clear. It's about prior criminal acts, criminal history. And there's no doubt that the act happened on March 25th, 1986. That's not in dispute. So it was prior to the sex crime. It's not in dispute, as Justice Schulman was pointing out in his questions, that the defendant was convicted. Now, why is the conviction important? The conviction is important just because it's a reliable indicator. It's not for what counsel makes it out to be, that it's some event in the process. What we're trying to find out here is risk factors for this specific risk factors in the SORA, and they go to factor 9 is prior criminal history. And it's 1, prior to the sex offense, so it fits. And 2, it's reliable because not only was he arrested, but he was then later convicted, and the conviction was before the sex offense. Not that I even think it has to be, but you're just looking for a reliable indicator to prove that he had this prior criminal history. And it's not in dispute that this was prior criminal history, was made March 25th, 2 months before he committed the sexual offense. And I just don't, sorry.
Go ahead.
I'm sorry, Your Honor. I was just going to say,
ahead.
there's just nothing, there's nothing in, there's nothing in the actual record for defendant, in the guidelines for defendant's point, and this is defendant's point, not my point, only when the individual subject to the SORA hearing had a prior conviction that predated the commission of the instant sex offense. That is nowhere in the guidelines. What is it? He had prior criminal history. And in this case, he did. And it's simple, and as the judge found, and I'll leave it unless there's further questions to the trial judge, the act preceded the sex offense, and the conviction preceded the conviction here. So under any standard you use, it fits. And that's why the 5 points were assessed. And I'm happy to answer any more questions. And if there are none, I'd rest on that.
Any questions? Okay, thank you, counsel. You have a minute for rebuttal, okay?
Yes, Your Honor. I just want to highlight 2 things. One, the guidelines on page 6 states, when offender has admitted to committing a sexual misconduct for which there has been no judicial determination, it should not be used in scoring criminal history. So here in the guidelines on page 7, it even says an admission should not be considered as criminal history, even though it would happen because it happened prior to a judicial determination. Subsequently, Your Honor, I just want to say
Counsel, I have a question. Are you suggesting that we also should not consider as very weighty his numerous infractions, many of which were sexual in nature, while he was incarcerated?
Your Honor, he received points in the category as to behavior while incarcerated. Those points were assessed, Your Honor. And I don't even think they were in dispute as to that category, but those points are not considered in factor 9, which is the only factor that is at question here. I do want to also highlight one more thing, Your Honor, is that, again, the guidelines on page 14 says some sex offenders have concurrent or subsequent offenses that are not scored in these categories and are not covered in this category, and instead a respondent should ask for an upward departure. So here, Your Honor, I just wanted to highlight that subsequent and concurrent offenses are not even considered in prior criminal history, and therefore these 5 points, which in technicality is subsequent to the sex offense, should not be considered.
Okay, thank you. Thank you both very much. Appreciate the arguments. Have a good afternoon, or evening, I guess. The next case is Matthias versus New York Hotel Management. We have the appellant, Mr. Valvo.
Good evening.
Good evening.
Got me? Okay. Thank you.
I hear you, I don't see you, but that's okay.
Anyone else see me?
Nope.
Huh.
Okay, well, you can talk, we hear you clearly,
okay.
So.
I'm seeing myself in the corner here, it just came on, so. Anyway, Well, it's,
Maybe you'll show up.
it's to your benefit that you can't see me, trust me. Very briefly, given the late hour, this is an appeal from the decision by Judge Thompson in the Bronx that denied our summary judgment motion and granted the diner's summary judgment motion on the third party action. This case is rife with facts. We believe the court never really looked at our expert affidavit in deciding this case. Our expert clearly set forth why the diner was responsible for the maintenance of the pipe in question. They were utilizing it. They had a kitchen that they were tapping into the line. And
oh, wait, but are you disregarding the other expert report that suggests that sewage from many floors of the hotel were also spilling into that pipe? Isn't there a very significant question of fact as to how this pipe was used?
Yeah, that's the whole point. There was a question of fact of how the pipe was used. And so therefore, as a matter of law, the court should not have granted the diner's motion. This is really for a jury to decide because you have conflicting experts.
You're saying that the third party action was dismissed. Your third party action was dismissed.
Yes, and it was granted. They also moved and it was granted. The diner, yes. And that's, so I'm really kind of working backwards in a way, because if you then find that that should not have been dismissed, then you can get to the next arguments where we didn't have constructive notice and things of that nature. So really, it's the court should not have granted the diner's summary judgment motion. They should not have denied our motion.
Well, let me ask, I want to ask you a couple things about your third party action against the diner. First, as far as I could figure out, correct me if I'm wrong, you had a few different causes of action in your third party complaint. There was a contractual indemnification issue, there was a breach of duty to procure insurance, and there was a breach of contract based on the failure to maintain plumbing. Is that right?
Yes.
So, did you then move for summary judgment in the event we reinstated your action against the third party defendant? Did you move for summary judgment on some of those causes of action?
On all of them, we did.
Okay, so I was wondering if you could, in a minute or so, tell me how do you are you entitled to summary judgment on the breach of duty to procure insurance? I mean, did anybody attach a copy of the insurance contract which says which shows that you were or were not added as an additional insured? I know that their insurance company would not agree to defend you. They declined a defense. Is that correct?
Correct. They sent a disclaimer letter, which is part of the record.
Okay, so has anybody looked at the insurance contract to see whether or not, in fact, you were named as an additional insured?
We were not named as an additional insured.
Okay, so that there's no, and do you also have to show any damages at this point in order to keep that cause of action going?
I don't believe so. I think it's just pretty clear that they didn't name us and therefore they breached the contract.
All right, could you discuss the contractual indemnification claim and why should that be determined at this point, or do we need more information in this case?
I think it was pretty clear. Paragraph 8 of the lease was an standard indemnification clause. The court never got to that because they just dismissed it. So they didn't reach any of the claims in our third party action.
But does paragraph 8 of the lease conflict with paragraph 51 of the lease?
No, they're basically the same. They're both indemnification clauses. They're not. There's nothing in the clauses that says that we're not responsible if we have gross negligence, and that's not been alleged here at all. Right. So there's no conflicts there.
So you might be entitled to conditional summary judgment on the contractual indemnification claim at this point.
Correct.
All right. Do you want to say anything now, or you want to wait till the other parties talk?
Let my esteemed colleagues go. It's late in the day.
Okay. Who wants to, who should I hear from first? I think I should hear from the third party defendant, or do you, a plaintiff, you want to address both of their claims? Because mostly I've been talking to the defendant about the third party action. So can I hear from her first and then you'll speak last, Mr. Dankner? Okay.
Yes.
Ms. Buckle, is that how you pronounce your name? Hi, you're muted.
Bulkley.
Bulkley. Okay, Miss Bulkley, you got 4 minutes. Go ahead.
Good evening, Your Honors. May it please the court. My name is Nicole Bulkley, and I represent the respondent, third-party defendant, TikTok Diner. As counsel stated, the lower court decided that the lower court decided that the motion should be granted as to summary judgment as to the third-party complaint that was filed by the hotel, because the lease is extremely clear that the diner should not have been maintaining the pipes in question. There's multiple provisions in the lease that state that the diner was not the responsible entity for maintaining the pipes. I can point, Your Honors, to record page 164, paragraph 4. I can point, Your Honors, to another page on the next page on page 165. Paragraph 4 of the lease, which the lower court relied upon, specifically provides that the owner shall maintain and repair the public portions of the building. Furthermore, on page 165 of the record, the lease states in plain language that the owner is to use and maintain and replace pipes and conduits within the demise premises. The lower court specifically used, go ahead, Your Honor, do you have a question?
Well, but you were renting a portion of those premises. So did you have any obligation under the lease to do any maintenance within your demise premises, which was the diner that you've been leasing for a long period of time, I believe?
That's correct, Your Honor. We had been leasing it for a very long period of time, but there's no obligation under the lease. The demise premises under the lease is specific to the diner. And the lease says that that the owner has the obligation to maintain and replace the pipes and conduits within the demise premises, which is the diner.
So you have no obligation to maintain it at all?
The pipes that are located within the diner, and as the experts have stated and the testimony has established, the pipes in question were running up through more than half of the hotel and had sewage in them, which multiple parties have testified to, that this did not emanate from the TikTok Diner, nor should the TikTok Diner be unreasonably burdened with repairing pipes that are for the sanitation of the hotel. I would like to quickly address counsel's.
But what about the other two? What about the other, counselor? But what about the other two causes of action in the third-party complaint, which I'm hearing? Sorry, I don't know where that's coming from. There are two other causes of action in that third-party complaint. If you didn't put their name on their insurance contract, how is that not a breach?
Your Honor, it's our position that the additional insured endorsement provision is irrelevant, as the endorsement was never triggered because the subject pipe was a structural component of the building. Paragraph 3 of the lease indicates that TikTok may only make non-structural repairs to the demise premises which do not affect utility services or plumbing. So it is our position that the additional insured provision never should have been triggered, and the lower court relied upon this by stating the Greater New York Mutual Company case versus Mutual Marine Office.
So are you arguing, counsel, I have a question. Are you basically saying that your client had no obligation to buy insurance unless there was no liability? That seems like a very strange argument.
Well, I mean, you never. No. Sorry. Go ahead.
No, Your Honor. What I'm stating is that the additional insured endorsement was never triggered because we did not have the duty to make. We didn't even have any responsibility whatsoever to make the structural repairs to the pipe.
What are you saying would trigger it? What
I'm
is
saying
the
would
trigger?
if the lease said that our duty was to maintain and make structural repairs in the building, including the pipes in question, then we would have a duty to add the hotel's additional insured in the policy, but that's not the case here. And the lease is very clear.
But Counselor, in fact, you had a duty to put them on as an additional insured. Then you have to cross your fingers and hope that maybe whatever damage doesn't fall within the policy. But that's not really how it's supposed to work. When you get into these kinds of when you enter into these leases, you're obligated to get additional insured coverage. Not like, oh, you get it, maybe it apply. I mean, you get it, and then later down the road, we figure out if it applies or not.
Counsel, I have a question. I apologize, Justice Kapnis. I'm sorry.
Go ahead.
Counsel, I just want to go back because I don't see any limited language in the contract. It says that TikTok is required to maintain, and I'm just going to say comprehensive general liability insurance, naming HSA and any mortgagees as additional insurers. And then it further directs that insurance policies must be written as primary policy coverage and not contributing with or in excess of any coverage, which SHA may carry. There's no limiting language. It's very broad.
I understand your point, Your Honor. However, it's our position that that additional endorsement provision should not have been triggered because of the paragraph 3 of the lease.
All right, could you? I just wonder because we're running out of time. Could you just briefly address the contractual indemnification claim?
Yes, briefly, Your Honor. Counsel relies on Article 42 of the lease of the rider, which states that TikTok is responsible for all repairs of all mechanical, plumbing, and electrical systems, whether or not the same are located within the diner. So essentially, this section of the lease is essentially making TikTok liable for any pipes, any plumbing located in the entire 43-story hotel when they only take up less than 0.5% of the basement. So it's really our argument, Your Honor, that this is just a commercially unreasonable clause on its face, and the court should not be relying upon it for contractual indemnification.
And what case law supports that argument?
The First Department in Luger Plumbing and Heating held that it is a longstanding principle of New York law that a construction of a contract that would give one party an unfair and unreasonable advantage over the other would place another party at the mercy of one should be avoided. The hotel is essentially asking the diner to be at mercy by making them responsible for all plumbing within a 43-story entire hotel when they occupy just the basement.
Okay, thank you. Mr. Danker, you want to address whatever you would like to address in your 4 minutes?
Can the court see and hear me?
Yep.
Fine. Jay Dankner of Dankner Milstein for the plaintiff respondent, Ramit Matias. Your Honors, this appeal, at least as it relates to my client, the plaintiff, is premised on the incorrect and false assertion that both defendants are out of possession landlords. They are not. They are separate entities, both of which have ongoing presence in the hotel, 60 plus employees from the New York Hotel Management Company, and at least one from the Unification Association handling commercial tenants, of which the diner was one. And the New York Hotel Management Company isn't even a landlord. Counsel referred you to page 164, that's the lease. The landlord is the Unification Church, Unification Association, and it's between it and the diner. The Hotel Management Company isn't even named in that lease, nor is it a signatory. Its function is to maintain the hotel and its structural components. And I want to point out to the court that this is not a structural defect case. It's a simple failure to maintain case, specifically that they admittedly didn't perform periodic cleanouts of the waste line, which we know took human waste, soap, shampoos, toilet paper, and whatever else goes down toilets and sinks and showers.
We got the picture.
Yeah, you got the point, Judge. I understand that. But it is coming from 500 of the hotel rooms, 40 floors up and out to the city sewer system. The fact that approximately 15 feet of it went through a small part of the diner's new kitchen doesn't mean that it was responsible for maintaining hundreds of feet of the hotel's waistline. And I want to note, because it's not really clear, that the clog which resulted in the blow-off of the improper cleanout cap was 200 feet downstream. It wasn't even in that 15-foot part of the waistline that went through the ceiling, attached to the ceiling of the new diner kitchen. And all experts who have opined on the issue said that cleanouts every 6 months to a year were required as good and accepted plumbing practice and maintenance. That's the purpose of these offshoots every 50 feet under the plumbing code, to prevent clogs, not to remove them. And the fact that they've admitted they didn't do it for at least 5 years at least presents more than a question of fact. So, bullet points. The defendants are not out of possession landlords. 2, the waistline was a structural component of the hotel. 3, it should have been cleaned out periodically by the hotel or the management company. And 4, they admit they never did so. So questions of fact abound here. Summary judgment was properly denied on the primary action under Rule 3122, which Mr. Valvo didn't even argue. He didn't even touch on that in his argument today. And so I respectfully submit the order appealed from should be affirmed. Thank you all. Unless you have further questions for me on the primary action, I will rest on my brief and waive the rest of my time at 5:25 p.m.
Much appreciated, Mr. Dankner.
Thank you, Justice Kavanaugh.
Mr. Valvo, you got 2 minutes if you want to address Mr. Dankner's argument or Ms. Boakley's argument or anybody else's.
Very, very quickly.
Sure.
Under Article 42, it says that it's supplementing but not limiting Article 4. It is understood and agreed that the tenant shall be responsible at its expense for all repairs to and within the demised premises, including these items. So it's not the whole building that they're responsible for. They're responsible for what's in the demised premises. Secondly, under Article 40, the diner is responsible for cleaning, including under paragraph D, keeping the drains, waste pipes, and sewer connections and mains free from obstruction to the reasonable satisfaction of the landlord. So there is an obligation on the diner to maintain the pipes. There is definitely a question of fact, given our experts, whether the diner was utilizing those pipes and whether they're responsible for cleaning it. Thank you. Appreciate your time.
Okay, thank you all very much. Have a good evening.
You too.
And last but not least, People versus Bailey. Somebody has to be last. So you're it. Miss Peng,
Yes,
you
thank
may
you, Your
proceed.
Honor.
Good afternoon.
Last but not least, may it please the court. My name is Jane Peng from Freshfields Brookhouse Derringer. I represent Mr. Bailey along with the Office of Appellate Defender. This is a case where the police officer investigating a crime selectively recorded portions of a video as evidence, but omitted the key portion of the video showing the commission of the crime. The prosecution does not dispute that everything from that day is on video, including footage of the person who allegedly used the fraudulent credit card. The police officer investigating that allegedly fraudulent transaction did not record video showing the very thing that he was investigating, the use of the fraudulent credit card. The jury was therefore entitled to an adverse inference charge, letting them know that there was this critical piece of evidence out there that the prosecution failed to preserve. Therefore, the lower court erred in denying the adverse inference charge.
Ms. Peng, this is Judge Schulman. But was that video in possession of the district attorney's office? See, if it was in possession of the district attorney's office and something happened to that video, then there was a breach of the duty to preserve it so that you can have the full video for purposes of defending, etc. But it wasn't. So then, therefore, why would there be a basis for an adverse inference?
So, Your Honor, the video was initially in the possession of the restaurant. However, it's well settled that private third parties, can turn over evidence to the police and to the prosecution, and the prosecution can be considered to constructively possess the evidence, where they, for example, download the video or copy the video. Here, the police officer recorded portions of the video with his personal cell phone. There's really no difference functionally between downloading and copying a video on, for example, a videotape, and recording portions of a video on your personal cell phone. At the end of the day, the police officer has collected that video as evidence. And
So
the police
counsel,
officer
is there,
here,
this is Judge Gonzalez, is there an obligation on behalf of the police to copy the whole video and preserve the whole video of a third party?
well,
Of
Your
a
Honor,
private party, let's call it just a private party.
well, Your Honor, the police officer here was investigating a fraudulent credit card transaction. What he recorded on his video all occurred after the transactions themselves. So, you know, we're not saying that the police officer has to go out and preserve, you know, 24 hours of video. What we're saying is if he's investigating a fraudulent transaction, then he needs to actually and see, and that video is available according to the restaurant manager, then he needed to preserve that available video. When he chose to record portions of the video and not the key portion of the video, he was effectively collecting it for the purposes of charging Mr. Bailey and introducing it into evidence at trial.
Is there any authority to back you up? That he had an obligation to record and preserve the video of a private party?
People v. Virouette, which is a Court of Appeals case, and People v. Lewis, which this court decided, are both instructive in this case. In People v. Virouette, a nightclub was in possession of the video. There, the video was downloaded by the police and then subsequently lost. In People v. Lewis, it was in the possession of a livery cab, I believe. And this court actually said that by the manner in which the police downloaded the video and rendered it incomplete, an adverse inference charge was required.
So in Lewis, the court said that it wasn't called upon to decide whether the defendant was entitled to an adverse inference charge, but rather opined that the charge sufficed to prevent prejudice. So that doesn't exactly back you up. And I'm looking at Matos from 2016, which says that the fact that the police copied part of the video recording doesn't place the full video within the people's constructive possession or control, even if the police viewed the full footage. So I don't know that either anything that you cited so far backs up what you're saying. Any more thoughts?
So, Your Honor, People v. Matos is distinguishable from our case here because in that case, the police merely viewed the video evidence. In our case, the police went a step further and recorded portions of the video onto his cell phone and chose to disregard other portions of available video. So again, there's no functional difference between downloading a video and recording portions of a video on your cell phone. So, you know, an adverse inference charge was required here.
Okay, I've given you an extra minute, so why don't we hear from the people and you'll have 2 minutes on rebuttal, Ms. Pango. Okay, Ms. Gorski? Good evening.
Good evening, Your Honors. Julia Gorski for the People, and may it please the court. Wanted to begin with the adverse inference instruction. It clearly was not necessary in this case, and the people do absolutely dispute whether there was additional video and that the police officer only recorded a portion of what was available. There's nothing in the record that supports defendant's claim that the police officer only recorded a portion of what he saw. Neither he nor the restaurant manager testified that they had personally viewed any additional footage. And even if additional footage existed, the record does not establish that it was ever in the people's control because the individual who suggested there was additional video was a private third party. And as this court has held, the people have no constitutional or statutory duty to acquire or prevent the destruction of evidence that's possessed by private parties. And in any event, given the strength of the people's case, any error with respect to this instruction was harmless.
Well, I mean, out of curiosity, what would the alleged video of the actual credit card purchase between the waiter and the defendant have added to this case?
It wouldn't have added anything. We had both the waiter and the restaurant manager testify that the defendant was hovering over the waiter at the station, that he presented both the fake credit card and his driver's license, both bearing his first and last name, Jesus Bailey. And there's also video surveillance that does corroborate the portion of the restaurant manager's testimony saying, you know, he followed me, he was yelling at me, there was a dispute and whatnot. So just because there's no video of the actual transaction with the credit card in the waiter's hand, that doesn't disengage anything that was already established at trial.
And in fact, am I correct that the trial court actually invited the defendant to comment on the lack of video evidence during summation, which I don't recall. Did the defendant do that?
I think potentially in closing argument. I know that they never moved for a trial order of dismissal on the identity issue, but in their closing argument, they were saying, oh, you know what, I think we actually might have the wrong guy, but I can't confirm whether or not they made the actual argument, but I'm assuming that they probably did.
Okay.
I'll quickly address the other 2 points. An expanded identification charge should be given when there's a close question of identity, and this case did not present such an issue. It's plainly a one-witness case. It's not a one-witness case. The waiter and manager each identified defendant in court, and both of their testimonies established that their identification of defendant was premised on their own personal observations and interactions with him. And quickly, just to touch on the excessive sentence point, given the circumstances of this case and defendant's criminal history, his 2.5 to 4.5 year sentence was entirely appropriate. I do want to note that defendant is already out of prison, so he's essentially asking for his parole to be reduced by 1 year. However, that extra year of supervision is exactly what he needs. Defendant received the minimum sentence for grand larceny in the 3rd degree in 2010 after he dressed up as a Brinks worker and stole $120,000 from 2 different businesses. He was released from prison early on good behavior on that sentence, completed his parole, and then proceeded to commit the instant offense. So his own actions show that he needs supervision once he's released from prison to ensure that he doesn't continue to commit these crimes. And if there are no other questions, we ask that you affirm.
Thank you.
Thank you.
Ms. Pang, you've got 2 minutes to respond to anything you might like to respond to.
Thank you. I'll respond to 2 points made by the prosecution. Contrary to what my adversary says, she said nothing in the record supports that the video would have added anything to the evidence already presented to the jury. Actually, we only had one eyewitness, who was the waiter, who saw the allegedly fraudulent credit card transactions. The restaurant manager admitted in several instances in her cross-examination that she'd never witnessed firsthand the credit card transactions. In fact, the waiter was the one who pointed out Mr. Bailey to the restaurant manager. Thereafter, she began to interact with him. And additionally, the fact that his name was on the credit card and his name was on the ID, that we don't dispute. But however, if there was video showing that someone else was the person using the credit card with his name on it, the prosecution's case falls apart. Contrary to the fact that it wouldn't have added anything, the loss of the video actually creates speculation, which People v. Handy and People v. Virouette. People v. Handy is a case that the prosecution relies on in their brief. The fact that the loss of the video creates speculation is exactly why an adverse inference charge is required here. And nothing further from me.
Okay, I just want to say, Ms. Pang, I know that you did this on a pro bono basis with your law firm, Freshfields, Bruckhaus, and we always like to take a moment to thank the attorneys and ask you to thank your law firm for letting you to do this pro bono work. Both of the arguments were very good, and thank you both for sticking in with us here the whole rest of the day and evening. At least I probably don't have to tell you to get home safely, maybe, or you're already there. In any event, this does conclude the oral arguments for today, and court is adjourned. Thank you all very much.
Thank you, Your Honor.